Hemmerite of the North Carolina Utilities Commission, and with me this afternoon are Chair Charlotte Mitchell, Commissioners Kimberly W. Duffley, Floyd B. McKissick Jr., Jeffrey A. Hughes, William M. Brawley, and Tommy Tucker. I now call for hearing docket number E7 sub 1304 in the matter of application of Duke Energy Carolinas LLC pursuant to North Carolina General Statute Section 62-133.2 and Commission Rule R8-55 relating to fuel and fuel-related charge adjustments for electric utilities. Pursuant to the State Government Ethics Act, I remind the members of the Commission of their duty to avoid conflicts of interest and inquire if any commissioner has a known conflict of interest with respect to the matter coming before us this afternoon. Let the record reflect that I have no such conflict and that my fellow commissioners have not identified any such conflict. North Carolina General Statute Section 62-133.2 provides for annual fuel charge adjustment proceedings for electric utilities engaged in the generation or production of electricity by fossil or nuclear fuels. Commission Rule R855 provides that the fuel charge adjustment proceeding for Duke Energy Carolinas LLC, that I'll refer to going forward as DEC, will be held on the first Tuesday of June of each year, and that DEC shall file its direct testimony and exhibits and shall publish notice prior to the hearing. On February 27, 2024, DEC filed its application to adjust the fuel and fuel-related cost component of its electric rates, along with the direct testimony and exhibits of witnesses Clark, Jeffrey Flanagan, John Swez, Kelly McNeil, Matthew Cameron, and Stephen D. Capps. Petitions to intervene were filed by Carolina Utility Customers Association, Inc., which I'll refer to as KUCA going forward, or CUCA, and by Carolina Industrial Group for Fair Utility Rates 3, that I'll refer to as SIGFR 3 going forward, on March 1, 2024. The Commission issued orders granting interventions for these parties on March 7, 2024. On March 15, 2024, the Commission issued an order scheduling hearing for this place and time, establishing procedural and filing requirements, and requiring DEC to publish notice of this hearing. On May 8, 2024, DEC filed supplemental testimony and exhibits of witness Clark. On May 9, 2024, DEC filed a motion for expedited waiver and proposed public notice. Also on May 9, 2024, the public staff filed a letter in response to DEC's motion. On May 10, 2024, the Commission issued an order granting limited waiver and requiring additional public notice. On May 14, 2024, the public staff filed a motion for oral argument and leave to file supporting briefs. On May 17, 2024, CUCA filed a motion for extension of time to file intervener testimony. On May 20, 2024, the Commission issued an order granting CUCA's motion for extension of time to file intervener testimony. The Commission further ordered that the parties may file pre-hearing legal briefs limited to the issue of the legality of DEC's proposed new EMF factor. On May 22, 2024, DEC filed a motion for extension of time to file rebuttal testimony, which was granted by Commission order on May 24, 2024. On May 23, 2024, the following filings were made. Direct testimony of CUC witness Jonathan Lai, confidential direct testimony and exhibit of SIGFR witness Brian Collins, direct testimony of public staff witnesses Evan Lawrence, Darrell Brown, and the joint testimony of public staff witnesses James McLaughlin and Michelle Boswell. On May 24, 2024, the Commission issued an order granting motion for extension of time to pre-file rebuttal testimony and exhibits. On May 29, 2024, both DEC and the public staff filed pre-hearing legal briefs on the proposed EMF factor. On May 31, 2024, DEC filed the required affidavits of publication. On June 4, 2024, the Commission issued an order scheduling oral arguments. On June 6, 2024, DEC filed revised rebuttal exhibits. Also on June 6, 2024, DEC, the public staff, SIGFR and CUCA filed a joint motion to excuse certain witnesses. On June 7, 2024, the Commission issued an order granting motion to excuse DEC witnesses Cameron, Cap, Swez, Flanagan, and McNeil, public staff witnesses Brown and Lawrence, CUC witness Lai, and SIGFR witness Collins from appearing and testifying at today's expert witness hearing. On June 7, 2024, DEC filed an agreement and stipulation of settlement and affidavits of publication for additional public notice. With that being said, I now call for appearances of counsel, beginning with DEC.
Members of the Commission, Robert Kalin appearing on behalf of Duke Energy Carolinas.
Good afternoon, Presiding Commissioner, Chair Mitchell, members of the Commission, LaDawn Toon on behalf of Associate General Counsel on behalf of Duke Energy Carolinas. Good afternoon.
Good afternoon.
Good afternoon, Commissioners. My name is Will Freeman. I'm a staff attorney with the public staff here on behalf of the using and consuming public.
Good afternoon, William Creech, C. Creech with public staff on behalf of the using and consuming public. Thank you.
Good afternoon, Matt Tynan with Brooks Pierce for CUCA.
Good afternoon, Christina Kress with Bailey and Dixon here on behalf of SIGFR 3. Thank you.
Okay. Good afternoon to all counsel. Are there any public witnesses who wish to be heard regarding the matter to be heard today? Let the record reflect that no public witnesses are present for the hearing and can that be confirmed by the public staff?
The public staff is unaware of any witnesses who are present for the hearing.
Okay, thank you. Before we begin with the evidentiary hearing, we're going to start with oral arguments this afternoon. But before we do so, are there any preliminary matters that need to be addressed first?
The company has one, Commissioner Cameron.
Okay.
With respect to, as you noted, the Commission issued its order on June 7th, excusing certain witnesses. I just want to confirm that the pre-filed testimony, exhibits, and affidavits filed by those witnesses that have been excused has been in fact entered into the record.
So we are going to hear motions when the evidentiary hearing gets started, and you can make motions to have the pre-filed testimony and exhibits admitted into the record at that time.
That's
And
helpful.
all attorneys will have that opportunity.
Okay, thank you, Commissioner
Thank-
Cameron.
So before we begin with the oral arguments, I will remind the attorneys who are going to be making the oral arguments, and that will be DEC and the public staff, is my understanding, that they will have a total of 20 minutes each to present their oral argument, excluding the opportunity and time for commission questions. So are there any questions before we get started about the oral arguments?
Commissioner Grant, will the company have the opportunity to respond to public staff's position with respect to this matter?
Yes, so you will, so DEC will have a total of 20 minutes, and you can reserve
time.
any amount, 5 minutes, or any amount that you choose for rebuttal after the public staff's oral argument. But the total amount will be 20 minutes, so you may elect any amount for rebuttal.
The company will reserve 5 minutes.
5 minutes?
Thank
Okay.
you.
Okay. From the public staff, are there any matters to address?
No, Commissioner.
Okay. So with that, we'll go ahead and get started with the oral argument, and we'll begin with DEC.
Thank you. Good afternoon. Again, Presiding Commissioner, Chair Mitchell, members of the Commission, LaDawn Toon on behalf of the company, Duke Energy Carolina. Thank you for the opportunity. Please can you let me know if you can hear me. Thank you for the opportunity to present the company's position with respect to its request to recover its prudent fuel costs, including truing up the EMF, which stems from its 2023 fuel case. As the Commission has noted, the company filed supplemental testimony where witness Clark explained that the company has experienced an under recovery stemming from its 2023 case during the test period. And the company will acknowledge that historically it has not come into the Commission to request true ups of an under recovery or an over recovery. And as we've explained, those amounts have been de minimis. And on balance, to the company's detriment, the company has experienced a net loss in those instances. Given the magnitude the company has experienced in the test year of approximately $8 million. The under recovery through the end of the year is still unknown, but given that magnitude, the company believes it should be allowed to recover its prudently incurred fuel costs. And that is consistent with the fuel statute. So I'd like to turn your attention to the fuel statutes, specifically Section D of the fuel statute, which specifically states that the commission shall incorporate in its cost of fuel and fuel-related cost determination under this subsection the experienced over-recovery or under-recovery of reasonable costs of fuel and fuel-related costs prudently incurred during the test period, based upon the prudency standards set pursuant to subsection D1 of the section in fixing an increment or decrement rider. It would appear that public staff reads the phrase during the test period to modify the phrase costs imprudently incurred. That reading from the company's perspective is incorrect. Instead, the phrase during the test period modifies the phrase the experience, under recovery or over recovery of reasonable costs of fuel and fuel related costs during the test period. In other words, the company shall recover the experience over recovery or under recovery of reasonable costs during the test year, absent a successful prudency challenge. And in the case before the commission, the company experienced an under recovery of its reasonable costs during the test period, inclusive of the 2023 EMF balance. And the statute permits this commission to establish an increment rider to account for that under recovery, which is to true up the EMF. To the extent there's any ambiguity with respect to the plain language of the statute, then the commission must interpret the statute in accordance with legislative intent. The EMF was established, or statutorily confirmed rather, in 1987 in Senate Bill 524. Section 2 of Senate Bill 524 expressly states the enactment of this act shall be construed as clarifying rather than changing the meaning of General Statute 62-133.2 as it was previously worded, as construed by the Utilities Commission and Commission Rule R-855, so that electric utilities will recover only their reasonable fuel expenses prudently incurred, including the fuel cost component of purchase power, with no over recovery or under recovery in a manner that would serve the public interest. It is clear from the General Assembly's intent that the fuel statute is intended for the company to fully recover its prudent costs, no more or no less. What's also clear is that public staff's position directly violates the legislative intent, because under public staff's position, the company will always be under recovered or over recovered. Why is that? The EMF rider and fuel costs generally are recovered through a volumetric rate. There's no perfect rate design. The company cannot predict with 100% certainty future kWh sales. The company does not have control over usage, much less weather. And weather is the strongest determinant of billings of sales, which is why the EMF is designed to account for over collection or under collection of prudently incurred fuel costs, allowing this commission to set an increment or decrement, as the case might be, to recover the EMF balance over time. In addition to the General Assembly's intent, which is clear, this commission's prior action indicates the commission understands that the EMF is in place for the company to fully recover its prudent costs. In E100 sub 47, implementing the commission's rules authorizing the EMF, the commission stated, the EMF will minimize and over time eliminate cumulative under and over collection of reasonable and prudently incurred costs, thereby enhancing the financial well-being of the utility while protecting the interests of the using and consuming public. This sentence makes it clear that the EMF is designed to, over time, eliminate cumulative EMF balances. However, under public staff's position, that would be impossible to ever eliminate the EMF balance, and again, put the company in either an always over recovered position or under recovered position. In that same order implementing the commission's rule, the commission said as long as the utility reasonably and prudently incurs fuel costs, it would over time be allowed to fully recover such costs. If the question still remains, does this commission have the authority to allow the company to true up its EMF? The short answer is yes. The commission can look to its order in Dominion's 2014 case. Dominion experienced an under recovery of its EMF during the test period. The Dominion came to this commission and proposed a mitigation strategy to spread the EMF over beyond the 12 months, similar to the agreement that the company entered into with public staff in sub 1282. As a part of that mitigation strategy, Dominion said, we would like the opportunity to true up our EMF. This commission, with public staff support, adopted that mitigation strategy in E22 sub 515, and then subsequently implemented the true up of Dominion's EMF in E22 546. So it is clear from the commission's order that the commission has the authority under the statute to allow an electric utility company in North Carolina to true up its EMF. Public staff's position not only is contrary to the fuel statute, express legislative directives, and again, commission action, namely the Dominion case, which I just spoke to, public staff position would result in a non-ideal policy outcome, as it would incent the company to under forecast billing period sales. If the EMF can never be trued up, the company's only option is to under forecast the billing period sales so as to result in a higher EMF rider that will increase the likelihood of full recovery of prudently incurred fuel costs, which could result in the company earning a windfall, which is not the intent of the company, and the company certainly would not design a rate to earn a windfall. In this case, the company, and in future cases, the company is seeking to request recovery of only its prudent and reasonable costs, no more or no less. Additionally, public staff's position, its approach, hinges the company's ability to fully recover its fuel costs on forecasting strategies and weather conditions. Again, weather being the largest driver of sales. There's no evidence in the General Assembly's intent to hinge recovery on usage and weather. This is not sound policy outcome. The company should be able to recover its prudent fuel costs in the proceeding and future proceedings, no more or no less, as intended by the fuel statute and confirmed by express legislative directives and commission action. And if this commission, despite the fuel statute, the plain language of the fuel statute, legislative directives, and commission action, namely the Dominion case, determines that the company's request is not permissive under the statute, the company requests that the commission uses discretion to issue a deferral to recover the 2023 EMF balance in a future base rate case. But again, the company's position is that the fuel statute allows the company to fully recover its prudent costs, and that intent has been confirmed by express legislative directives, has been confirmed by the order in E100 sub 47, as well as the mitigation strategy adopted for Dominion in E22 sub 515, as well as E22, where implemented the final true up in sub 546. I appreciate the opportunity again to present the company's position. I'm happy to answer any questions that the commissioners might have.
Thank you, Ms. Toon. And I noticed that you do in fact have 5 minutes for rebuttal. So you timed your presentation well. So let me start very generally, and I have some questions and then my fellow commissioners may as well. You stated that historically DEC has not requested a further true up for an under recovery amount because there had not been a substantial enough of an under recovery. Help us to understand what DEC would view as substantial enough to request an additional true up for either an under recovery, and then also what would be a substantial over recovery that would need to be addressed.
Yes, so historically, the amounts have been de minimis, so less than $5 million between the two utilities. And again, I think between DEP, maybe roughly a $3 million net loss, DEC roughly a $3 million net loss. The company fully acknowledges that its decision to not come in and true up those prior amounts is inconsistent with the fuel statute. And that not only in this case, but going forward, that the right thing to do in accordance with the law and in terms of good policy is to come in irrespective of the dollar amount and true up the EMF balance, whether it's an under recovery or an over recovery.
So depending upon what decision the commission might make in this case, the practice of DEC and also DEP may be changed going forward. Is that what you're saying?
Yes.
Okay. And then, so I'm going to go ask a question about the Dominion fuel rider proceeding that you're talking about toward the end of your argument.
Yes.
And so really what the crux of this argument is, Duke and the public staff disagree about whether the fuel statute allows the EMF to be trued up a second time or a third time, or trued up outside of a settlement. And I think that's the kind of the crux of the issue. And in the Dominion fuel rider proceeding that you talked about, and that also was cited in the public staff's brief, this is an instance in which a additional and kind of final true up occurred, but that was part of a settlement. And so can you talk about, I think the public staff's position would be that final true up would be allowed because it was agreed to as part of a settlement, and the commission recognized or approved that settlement. How is this consistent with the Dominion fuel rider proceeding that was part of the settlement?
Yes, so the fact pattern in Dominion is similar to the fact pattern of the case before the commission. The only difference being that there was no pre-authorization of a final true up. But the question should not turn on whether the parties agree, because the public staff does not grant the commission authority. The question should turn on whether the commission has the authority of the fuel statute. And so when the commission adopted that mitigation strategy and then implemented a final true up, it's the company's position that the commission understood that it has the authority under the fuel statute to allow a utility company to true up its EMF.
So your position is irrespective of whether there's a settlement or not, the commission has that authority regardless of whether it was agreed to in a settlement.
Correct.
Okay. And then what I want to talk about is the interpretation that you discussed about, you talked about on page 4 of your brief, and I'll just, for reference, read what you specifically stated in your brief that you talked about during your oral argument. You state, public staff apparently reads the phrase during the test period to modify the phrase cost prudently incurred. You state that this reading is incorrect. Instead, the phrase during the test period is appropriately read to modify the phrase the experienced over recovery or under recovery of reasonable costs of fuel and fuel related costs. And you have argued just now and in your brief about the legislative intent of Section 2 of Senate Bill 524 to ensure that there's no over recovery or under recovery of fuel costs. And I'm going to ask about this legislative intent in a minute, but other than the legislative intent under Section 2, is there a commission order or case law or any other authority that specifically states that a true up outside of the 12-month true up period is allowed? Is there anything that specifically states that that proposition?
Well, I think that the commission's order implementing its rule regarding the EMF explains that the EMF is in place for the company to recover its prudent costs over time. And only way to recover those costs over time would be through the EMF.
Okay. And then about the legislative intent under Section 2, I want to make sure we're clear about Section 2 of Senate Bill 524. Is that section of Senate Bill 524, is that uncodified? Is that an uncodified provision, or are you aware?
I believe it was a codified position, but I will follow up with you, Mr. Kimmerer. I apologize.
Yeah, it was not clear to us whether it is uncodified or whether it had actually been passed into law with a statute number. But if you could follow up,
Well, I will follow up.
okay, follow up after the hearing to let us know. And then if it is uncodified, how should the commission consider that as legislative intent if it was never actually codified into law?
The question is understood. So I will follow up, Mr. Kimmerer, and then if it, to the extent it is not codified, then the company will address how
Okay.
the commission should interpret it.
Okay. And looking into legislative intent that you are discussing with Section 2 of Senate Bill 524, usually I think that the statutory construction states that you consider legislative intent only if the statute is ambiguous. Is it your position that the statute is ambiguous and therefore legislative intent should be considered, or is it your position that the statute is clear and therefore interpretation is not necessary?
Is the company's position that the plain language of the statute is clear? But to the extent that the commission determines that there is ambiguity, then the next step would be to interpret the statute to give legislative intent.
Okay. Thank you. I'll check now to see if my fellow commissioners have any questions. Okay. Thank you very much. And we'll hear from you on rebuttal for 5 minutes.
Thank you.
Okay. Now we'll turn to the public staff.
Thank you, Commissioner. This is Will Freeman, and I want to make sure we understand what we're talking about here. In last year's fuel rider, E7 sub 1282, DEC compared how much money it forecast to collect versus how much money it actually collected and determined that it was off by $998,429,185. And so DEC had not collected enough money to hit that $998 million in expenses. And so the public staff and DEC came to a settlement where rates were based on recovering that over 16 months instead of 12, and Duke charged a 4% interest rate, which was $6.6 million of interest. And because of that settlement, customers' bills were not 18%, but 13.31% increased. So a savings for customers. And now Duke wants to go back into the 1282 case that was agreed to by Duke and ordered by this commission and true up. We're talking about last year's fuel rider in today's proceeding. That is not contemplated by the law. And we're here under the fuel statute, and I put a copy on everyone's desk. That entire statute is focused on fuel costs for this proceeding. And that's why on page 3, they talk about submit data about this fuel year, and DEC's fuel year runs January 1st to December 31st, 2023. Submit the cost of fuel for that year. This whole statute is designed to address 2023 fuel expenses. And what Duke is trying to do is fit a square peg into a round hole and say, we also want to pick up about $8 million of expenses from the 1282 that we are not recovering. That is not appropriate for this fuel statute. And that is shown by the plain language on page 4 or 5 of the statute that I handed out. The commission shall incorporate in its cost of fuel determination the experienced over or under recovery of reasonable cost of fuel prudently incurred during the test period. You have to read with some mighty big ellipses in order to make it say what Duke says it says. I struggle to make it not say we're looking at last year's fuel costs. This is the fuel rider statute talking about 2023 fuel costs. You can't dip into the under or over recovery from 2022 in this statute. That's not what it's designed for. And so I don't think we need to do much more than look at the plain language. I don't think we need to talk about prior years under recovery in this proceeding. We're here today to, I'm gonna read with ellipses, to recover fuel costs incurred during the test period, 2023. 2023's fuel costs, not 2023 money we didn't get from 2022 fuel, right? I think that we need to just generally understand that this is a very rule-oriented area of the law. We set rules and then people move forward based on them. Don't go look at what happened afterwards and go back in time. That's retroactive rate making. Set rules. That's what we do going forward. We abide by those rules. It's the ahead of timeness that is so important for utility law to be a law and not just this amorphous, equity-driven, we're going to get money. And it's also important to remember, we do not set a revenue target and then stop. If Duke has $998 million that it's owed, has 998 million kilowatt hours of forecast sales, $1 an hour. If there's less, Duke undercollects. If there's more, Duke overcollects. You set rates based on costs, informed by forecasts, and hopefully you hit the target, but it's never hit. None of the rates, general rate cases, fuel riders, any of the riders you're going to hear today, they always come close, but they never hit exactly. Because we set rates based on forecasts. And I think even Duke conceded that in their argument today. So why don't we guarantee cost recovery? Why don't we say hit this target and we're done? Stop taking rates. This is the private sector. This is a business operating in the private sector. There's risks on every business operating in the private sector. Duke has an opportunity to recover its costs. Duke has an incentive to efficiently manage its business to recover its costs, but we do not guarantee this business will recover its costs. No guarantees. And we use casual language because we talk about these concepts often. We say, oh, Duke will get this, Duke will get that. What we mean is we're going to give an opportunity to address a cost based on forecast data. And casual language in briefs that say otherwise don't really capture the fundamental concept here. So we have this bucket of $998 million and turn on rates and we try to fill it up. And in this case, as of March 31st, the bucket is about $8 million shy of where Duke thought it would. And Duke's best guess is that by December 31st, the bucket will be about $17 million shy of where Duke thought it would be from the last fuel rider, 1282. So that means even by Duke's own forecast, it's going to get 98.3% of its costs. The forecast here is so important, and it's telling that we use Duke's forecast in the settlement, and the commission adopted it 100% complete. The forecast that Duke based its recovery on was in the settlement agreement, the identical ones adopted by the commission. So we're here today because Duke's forecast was off. You cannot go back now and say in the 1282 case, turns out we should have used a different rate, should have forecasted differently. That's retroactive rate making. It's not allowed unless you talked about it beforehand. And that's the key difference in the Dominion case. Dominion came in and filed testimony. Said, we're going to do this. 0% interest, 2-year recovery period, and we want a true up at the end. Everybody knew that going in. It was in the commission's order going forward. But there were 2 fuel cases, and then the last one came in. Hey, we're going to do that thing we told you we're going to do. We're going to true up the true up. And in this case, we had 16-month true up, 4% interest, and no negotiated term about truing up the true up. That's just such a huge difference. It's important to remember that in the many cases telegraphed from the beginning, we're going to be doing this. It was known, the rules were followed. Here, after the fact of going back. That's what makes one retroactive rate making and one following rules. Just a couple of more reasons why I think Duke's interpretation of the law is incorrect. In the olden days, there was no debate. You set rates, made your forecast, and that was it. And in 1985, a charming and witty attorney named Robert W. Kaler, working for Carolina Power and Light, came before the commission and said, we need a true up, and the commission agreed. And in 1986, the commission adopted an order and said, everybody's going to get this true up. And when they adopted that order, they telegraphed a number of things to folks. And the order is in the packet that I put in before you, was also discussed by Duke, but the whole order is here. And if it's second document in the packet. At page 7, that document says the EMF will minimize and over time eliminate the cumulative under and over collection of reasonable and prudently incurred fuel costs. That is over the long horizon of decades that this law has been in place. It will go up and it will go down. But the goal is to aim for 0. And on page 8 is where the commission really tells us what they're thinking. There was a fear, I think, and of course, I wasn't around, but there was a fear, I think, that, hey, if you're going to let the commission, if you're going to let utility true up, they don't have any more incentive to be a good utility, to be efficient. And the commission in 1986 said, not to worry. One of the reasons the utility will have to make good estimates is because of the, quote, potential cascading effect of unintentional but nevertheless systemic over or under collection of reasonable and prudently incurred fuel costs. Don't get this stacking, you don't get this cascading, you don't get this on top of each other. If the true up is happening right away. What the commission is telling us in 1986 is that the risk of accurate forecasting is still on the utility. That's the business they're in. They're keeping the risk of running their business. They're keeping the risk of accurately forecasting. It doesn't fall on ratepayer, it falls on the business. That's what this order from 1986 is telling us. Now, Mr. Kaler, despite winning in 1985, in 1987, the North Carolina Court of Appeals said actually the statute does allow for true up. It's not spelled out 100% clear. It's just not there. And they struck down the EMF. And in July of that year, the legislature passed the law and said, actually, we did want there to be a true up. They added in language that said there was a true up. Then they added in this section 2 that we have discussed. It's the third document in the packet here. And the legislature, I guess, gives us insight, regardless of whether it's codified or not. And I think you have to find it in the session law, not a statute. But regardless of whether it's codified or not, we get a big hint here from what the legislature thought. And what they do is they say, hey, we liked how that 1986 rule was, quote, previously worded and construed. The legislature is telling us we like that thing that was said in 1986, where the risk stays on the utility of accurate forecasting. And just gives a little more oomph to the commission's order back then. There is no implied, you will recover every single penny of costs. You will be given an opportunity, but not a guarantee. Another reason that I think that we struggle with reading the statute as Duke does is that this law is narrowly construed. Remember, the 1987 court looked real carefully and didn't see it there. And rather than keep this law real small, they're stretching it out as big as they can and trying to make a hole here for a thing that has not been done. 37 has not been done. In 2003, a charming and smart lawyer named Kendall Bowman sat where Mr. Kaler is sitting now and was working for CP&L and faced with KUKA wanting to do a true up of the true up. And as CP&L said, hey, this is a true up of the true up. And they said, well, we're doing this properly. The commission had the issue presented to it, but said, we're not going to decide it. But in 2003, Kendall Bowman, now President of Duke, thought that the system that we've been doing for 37 years was appropriate. I just get back over it. It's been this way since 1987. That means the commission's been wrong since 1987. Public staff's been wrong. Everyone's been wrong. Duke had this secret understanding of the law. Didn't convey it to anyone. It's been doing it wrong. And now Duke sees a number that it arbitrarily decides is de minimis or not de minimis, and then decides to come before the commission. Duke has the obligation to file for information here. For the 3 years from 2017 to 2019, DEC cumulatively collected more than its fuel cost of $4,765,316. In the 1 year of 2020, DEP cumulatively collected $4,537,584 more than its fuel costs. They over-collected. Why didn't they come in and say, hey, we got this big number, what should we do about it? It just seems like you'll only raise this issue when it benefits them. Are we gonna reopen all these? Is that the principle now? Do we go back and start charging interest on these cases from 10 years ago? Set rates, and then that's how it works. Set rates, we hopefully hit the target. Are we gonna go investigate the O&M in the rate case? If they lay off a lot of people after the rate case order comes out, we're gonna say you're over collecting for O&M. In the EDIT riders, we're flowing back $240 million over 5 years to ratepayers. That's E7, sub 12, 13, 14. And then flowing back $87 million over 2 years to ratepayers. Should we check on those numbers? Say, did the ratepayers get everything? We don't do that because that's retroactive rate entry. We don't start opening things up again. We follow the rules before the game starts. Can't change the rules after it starts. We do not guarantee that every penny will get it. Another reason that I don't think Duke should prevail here is that Duke made a settlement. Regardless of what the law says, Duke made a deal. Got to stick to it. And that deal was in order of the commission. Ultimately, it became adopted by the commission. And they haven't moved to open up the 1282 rate case. They haven't moved to undo the deal. They just say, we have this equity position. And I think Duke is somewhat aware that maybe the law is not quite on its side because it has this deferral argument. So listen, if you don't like that, we need a deferral. Deferrals are for things like hurricanes, COVID. They're not for the fuel rider statute. It's almost a deferral itself. Only unique statute that addresses the topic thoroughly. You don't need a deferral when you have a law that addresses it. The last point I'd make is the frankly stunning argument that Duke now is incented to under forecast the period sales, and that if it did this, the company could earn over the fall. I know they said they wouldn't do it, but why didn't you write that in your brief? What a shocking thing for a company to say, I now have an incentive to fudge the numbers. I now have an incentive to put my thumb on the scale. I now have an incentive to get more money than I'm entitled to ratepayer. That is shocking to hear from a company that has a monopoly awarded by the commission. It is frightening and not something that I hope that was written and said even the moment, and certainly doesn't reflect the intention of this company or the incentives that this company has to the ratepayers. So it's that cap. You let me consult with Mr. Creech just for a moment. Thank you very much, Commissioner.
Thank you, Mr. Freeman. I will let Ms. Tu know that one of the questions I'd like for her to address is your last statement about potentially incentive to over-recover from, under-recover from fuel sales, as mentioned by Mr. Freeman. Okay, but questions for you, Mr. Freeman. So let me start with some of the arguments that you made toward the end of your presentation. You talked about Duke over-recovering, or DEC and DEP over-recovering in the past few years. I believe that the information in the briefs state that Duke under-recovered over a period of 10 years. Can you address that so we can be clear on the record about the net either over or under recovery over a longer period of time?
I apologize if I was misleading. Absolutely, you're correct. Net over the period of time that Duke went back, it has not recovered. It has gotten less than its fuel costs. So it's out, under collected, $2 million-ish, almost $3 million for DEP and DEC. I was highlighting that Duke didn't come forward in those years when it was over earning, and I apologize if I gave a different impression.
And would you What is the public staff's position in response to what Duke has stated today, that going forward, they believe that the more appropriate way to handle either over recovery or under recovery is to have a true up every year, so that there can be so that there will be no over recovery or under recovery as required by the statute, and so change the way that we're doing things going forward.
I'd say two things on that topic. First, I don't think it's contemplated by the law or the commission rules. I don't think it's allowed, quite frankly. And second, I think we don't do that in any other area that we set rates and we aim for targets, but we never in any other that I'm aware of do we say we're going to get the exact penny and we're going to just keep. That makes it perpetual because you'll always be a few dollars off. That's where we get into this. Now we've just made a whole new rolling balance that's gonna kind of tsunami into this eternal EMF. And I just don't think the legislature had that in mind. And it'd be different if we did that in other fields too, if that was how the DSME worked or something.
Okay, and I'll get to the kind of legislative intent in a minute, but you also talked about for many years, since 1987, that Duke has not come in seeking another true up. But would you agree that the magnitude of the under recovery makes this proceeding somewhat extraordinary, because they have not, there's not been an under recovery of about $8 million. It's been forecasted to increase to about $17 million over the remainder of the period.
Okay, again, two answers. One, I'd say that's about 1.7% of the money at issue. With respect to the magnitude, I don't want to venture far outside of what I think the law allows whenever there's a number that's large according to Duke. Because I guess who should this fall on? Who should the risk of the bad forecast fall on? Should it fall on ratepayers or should it fall on Duke? And I think the commission told us in 1986, they're a business, sometimes that's what businesses do. They are not a guaranteed cost recovery entity. And so I think that the business made a business mistake, and in this particular situation, we'll undercollect slightly, 1.7%.
And then, so I'm going to change gears. I'm going to go to what you talked about at the beginning of your presentation of subsection D of the statute. And it states under subsection D, what you've highlighted, that the over recovery or under recovery portion of the increment or decrement shall be reflected in rates for 12 months. Can you help the commission reconcile? You said that we need to be focusing on the plain language of the statute and the rule, but yet we have a settlement that in the previous rider proceeding that was not 12 months, it was 16 months. And then we also have both Duke and the public staff cited to the settlement and the Dominion proceeding, which was over, the recovery period was over 24 months. And then there was at the end of that, and then in the next rider proceeding, a final true up. How do you reconcile saying that we need to follow the black letter of the statute with these modifications in settlements?
And that's why the settlement is so important. Duke waived its right to get a 12-month true-up. Duke chose to voluntarily forego the 12 months that you just discussed and said, hey, we know that we have this right under subsection D, but we're going to, in the interest of mitigating some of these huge increases, allow our right to be to extend to 16, allow the recovery to be 16 months. So this is a right of the utility that can be settled or bargained for as part of the give and take of settlement.
Okay. The statute doesn't specifically state that, though, does it?
It does not, but that is that's how I read it, is that this is the right that Duke has, and it can give it to us or give it to the settling parties if it wants. But I take your point. I take your point, but I think that also gets back to my argument on how things have been done. There have been many stretching out more than just the Dominion, but it's happened many times. And so I think kind of history informs us there too.
Okay. So your position is that either you have to comply with the statutory 12-month period or the period that's included or agreed to in a settlement. We want to make sure I'm clear about the public staff's position. Are you also saying that the commission doesn't have the authority to extend the scope of the EMF recovery to costs either incurred or not recovered outside of the test year of January 1 of 2023 to December 31 of 2023?
Well,
Are you saying both? We don't have authority for either.
if you'll recall, I think in the 1282 case was where we made the argument that under the sort of general just powers of the commission, we could extend the 24 month, but we could extend it to 24 months. And we pointed to why we thought that was appropriate. We settled before the commission ever reached a decision on that argument that we made in that case. So we never got a decision, but we have in the past, the public staff has in the past occasionally advocated for longer than 12 months, at least on one occasion that I know, longer than 12 months over an objection of utility. But again, that was never resolved. There's not an order I can point to.
And then going to Senate Bill 524, Section 2 that both you and DEC have cited to. Do you know whether that is uncodified? Do you have any information about that?
I don't know, and I don't want to give an, I have some guesses, but we all have guesses. Let me get a more firm answer to the commission.
Okay. And same instruction to the public staff that we'll be talking about proposed orders at the end of the evidentiary hearing, but that can be addressed in the proposed orders about how Section 2 should be applied to interpretation, if at all, to the statute. And same question for the public staff that I asked of Duke is, do you believe that the statute is unambiguous? And if so, you have talked about Section 2 of 524, Senate Bill 524. Is it necessary to talk about legislative intent if your position is that the statute is unambiguous? I'm
going to copy Ms. Toon's answer. I think it is unambiguous. I don't think we have to go further than the language of 62-133.2. But if you do, I think we've got a very strong indication that how we've been doing it since 1987 is still the correct way.
Okay. Thank you very much. And I'll check to see if my fellow commissioners have any questions. Okay, seeing no questions, we'll turn to Ms. Toon for rebuttal.
Thank you, Commissioner Cameron. And at the outset,
I apologize. Okay.
I'm a newbie. I'm not sure what to do, but I looked at the General Assembly website and looked up Senate 524 of 1987, and it was codified as Session Law 1987-677.
Thank you.
And that was, I was passing you a note for that rather than shout out.
Okay.
So I apologize.
Okay, thank you. Now we'll turn to rebuttal, please, Ms. Toon.
thank you, Commissioner Brawley. Thank you, Commissioner Cameron. At the outset, I would like to address Commissioner's question with respect to the incentive that would result if the company is not able to fully recover its prudent costs. As we stated, we would never intentionally design a rate to earn a windfall. It's not our intention to over-recover in that regard, but it is reasonable for the company to want to recover its prudent costs in accordance with the fuel statute. And with that respect. And then I will address a few points that Mr. Freeman has made. He initially started out mentioning that the fuel case is about the test period. The company's under recovery it experienced with respect to the 2023 fuel balance was experienced during the test period. So we are talking about the test period in this proceeding. Also, Mr. Freeman has mentioned base rates a few times. I think Mr. Freeman is conflating general rate making in a base rate case with the fuel rider. The fuel rider is a separate rider which addresses fuel costs. Those costs are unique. The company does not make money on fuel costs. It is allowed to recover dollar for dollar its prudent costs of its fuel and fuel-related costs. And also with respect to the discussion around agreements, certainly the parties can't enter an agreement and the commission approve an agreement that violates a statute. It is clear that the commission has the authority to allow the company to true up its EMF. That was made clear in the commission's order with respect to the Dominion case. And the commission, in its order implementing its rules, has gone on to say that the EMF over time will help the company eliminate its prudently incurred fuel costs. And finally, Mr. Freeman has mentioned a number of times that we never true up an EMF in any matter. And again, we are focused on fuel. And so I'm very companies very cognizant of the fact that we are here to talk about fuel costs and our recovery of fuel costs. But we actually true up in the jar rider, and we also true up on an ongoing basis in the DSMEE docket, going back, I think, 5 years. So we can reach back 5 years to do the true up. So the idea that this commission has never trued up an EMF is incorrect. But again, focusing on the fuel statute and focusing on the fuel case before the commission, the company's position is that the request to true up its EMF to recover its prudently incurred fuel costs is consistent with the fuel statute. And to the extent there's any ambiguity, it is consistent with legislative intent and confirmed by this commission's orders in implementing the rule authorizing an EMF, as well as the Dominion case where the commission approved a mitigation strategy that allowed for a final true up of the EMF. And just for the record, the JAR rider is the joint agreement asset rider. That is a rider in the Duke Energy Progress annual riders. Again, thank you again for the opportunity to provide rebuttal, and happy, of course, to answer any questions that the commissioners may have.
Are there any questions from the rebuttal argument? Okay, Chair Mitchell.
Just a quick one. Reading a sentence in your brief, page 9, the last paragraph right before section 4. I'll just read it quickly. Instead, the company should be able to recover all of its prudent fuel costs, no more, no less, where a material amount of under or over recovery remains. After application of an EMF, the company should be permitted to recover such material amount. What you touched on this a minute ago in response to Commissioner Duffley, I think, but just again, help me understand what is material and what is de minimis.
I think in the past, the de minimis amounts has been roughly somewhere between 3 and 5 million. I think going forward, and the company has acknowledged that our historic practice is not consistent with the fuel statute, but going forward, I think anything material is any amount. And so that the company should true up any under recovery or over recovery going forward, irrespective of the dollar amount.
Is there, I hear you, is there something in particular about this case that is relevant that we should understand? I mean, what's going on here? You know, why now? Why now and not in the past have you come in and sought to true up the EMF?
Yes, Chair Mitchell. And so, as you know, in the 2023 docket, sub 1282, we were dealing with an almost $1 billion under recovery. So it's a very large under recovery. And as Mr. Freeman indicated, the company entered into an agreement to reduce those impacts to ratepayers. We have been monitoring the recovery of the 2023 EMF balance. And to date, starting with the billing period, which commences in September of 2023, through March of this year, as we extended our EMF, the company has experienced an $8 million under recovery, directly tied to our decision to extend the recovery period for 16 months. Again, because we understand that large bill impact, we want to reduce that impact for customers. And so as we stand here today, Mr. Sykes and Ms. Clark will be able to speak to the details behind that, but that we are under recovery. We have experienced an under recovery of $8 million, and we're projected to be under recovered roughly 17 million, and even that number is still unknown. And so the amount is material. And so we're here requesting the opportunity to true up the EMF to recover those amounts, and acknowledging that our historic practice has not been consistent with the fuel statute, and also to make the commission aware and public staff and the other parties in the docket that the company's position that the right approach going forward is to true up irrespective of the dollar amount, whether it's a recovery or an over recovery. Apologies.
But just one more follow-up. But in light of the concern that's been expressed, at least as I understand it by the public staff, sort of the never-ending true-up cycle that you could get into. I think maybe he called it a cascade, I don't know, but just the true-up after true-up after true-up. And, you know, how do you, and again, I hear the company's position, which is we're going to come in and we'd seek to true it up regardless of, you know, the amount involved. But if we're focused on this past practice of materiality, when is it important enough to the company? Is there some, and I don't mean dollar amount, but at what point is it material for the company to get in here and get that amount recovered? Why is it significant? Or, you know, conversely, is the public staff going to come to us and say that money should go back, that over recovery should go back to ratepayers? It's enough that it makes sense to go back to ratepayers. Is there some driving principle there?
Yeah, I think there's two driving principle. One is financial impact. And so the company is always and is required to be prudent as it relates to its financial health. And so financial impact is one factor, but also we think it's good policy going forward to true up those balances, because otherwise the company, if it's over recovered and under public staff position, it would not be permitted to refund a credit. And now we are, as I said, have experienced the $8 million through March 31st of this year, and the projection is still unknown. Now we could have a really hot summer, a really cold winter, and that could switch and be an over collection by under a public staff position, acknowledging historic practice. If we were under recovered 10 million over recovered 10 million or over recovered 20 million, we wouldn't be able to refund that back to customers. And we think going forward, again, acknowledging historic practice and in recognition of the fuel statute, its intent, commission action, and legislative directive, that going forward, the right thing, the right policy is to make sure that we recover no more or no less. We do not earn money on fuel. And in order to do that going forward, irrespective of the dollar amount, we want to be in a position to refund customers. Otherwise, we don't want the customers to be in a position where they are overpaying in a perpetual basis either. If we've over collected, then the customers are due a refund plus interest by statute. And where we've under collected, the company is reasonable in wanting to collect its prudently incurred costs consistent with the statute.
And Commissioner Duffley and Commissioner McKissick have questions, but following up, before I turn it over to them, following up on Chair Mitchell's question, talking about the under recovery, if the 12-month the period had been sought for the under recovery, what would be, and this may be a question for your witnesses if you can't answer, but what would have been the magnitude of the under recovery if it had been sought over a 12-month period as opposed to over this settlement agreement 16-month period?
So I understand your question, Commissioner Van Wright, to understand what the difference would be. What would our position, undercover position, be if we did the normal course of recovering over the 12-month period?
Right. Would there be a substantial difference between the under recovery of $8 million if you had been seeking to recover it over a 12 versus 16-month period? I think you said that one of the reasons for the under recovery was because of the 16-month recovery period as opposed to the 12-month recovery period.
And I can answer that subject to check by our witnesses, but I believe that we would be under recovered by $4 million.
Okay. Thank you. Commissioner Duffley.
So I was going to ask about Mr. Freeman's symmetrical argument with respect to the over recovery and under recovery, and let me make sure I heard your response, and if you could just confirm that I heard correctly, because Mr. Freeman mentioned $4 million recovery. So I was going to ask about that over recovery and say, well, why didn't you seek to blow that money back and ask about kind of this, you know, having some symmetry here with over recovery and under recovery. But then what I thought I heard you respond to Chair Mitchell is that from 3 to 5 million, you view that as de minimis. And so you don't really seek the over recovery or under recovery. But over 5 million, that's when you look at doing a true up of the true up. Did I hear that correctly?
Yes, we view those prior amounts as de minimis, as you indicated, Mr. Duffley. I think and I will say this and make sure that Mr. Sykes and Ms. Clark confirm or corrects me. But I think for the first few years in the past, in that sort of 10-year bucket, we were under recovered for multiple years. And then there was an over recovery, and then we were able to net sort of that under recovery. And then there was another, I believe, over recovery, and then we switched back to a under recovery. So yes, the amounts were de minimis, and they were roughly between three. I think the most might have been maybe 4.5 million. And as I said, our practice is not consistent with the fuel statute. And here where we've experienced already an $8 million under recovery and projected to have an additional under recovery, the company is coming in saying, you know, we'd like to recover our costs inclusive of the 2023 EMF balance of 8 million, and going forward, be able to true up under or over recoveries.
Okay, and then with respect to, you mentioned historic practice in your arguments. Are you meaning the Dominion case when you say
No,
historic?
I mean, the company's practice to not come in and true up.
Okay. No, I've
Oh,
moved to a
you moved
different
on?
part.
Oh.
Yeah, you were responding, I think, to Commissioner Kimmerite, and you talked about historic practice. It was a laundry list, and I just wanted to drill down. What did you mean historic practice?
I may have misspoke, but I think what I was saying is that the request to true up the EMF is supported by the fuel statute, legislative directives,
Right.
and action by the commission.
Okay.
With respect to its order in implementing the rules authorizing the EMF, as well as its orders in the Dominion case where it adopted the mitigation strategy and
Right.
then implemented the true up.
So in that instance, when you were laundry listing, your historic practice meant the Dominion case.
Correct.
Okay.
And should have said commission action.
And then my last question is, you made an argument on rebuttal with respect to truing up EMF. It's done in JAR, the JAR rider and the EEDSM rider. Those are different statutes. Do they have similar language to the fuel statute, or is it different language within those statutes?
The language is different, and my intent in bringing that information forward is for clarity of record in response to Mr. Freeman's arguments. I believe the JAR rule specifically says it in the rule, but not in the statute.
Okay.
That the company is allowed to true up its EMF, and by function of the mechanism, which I'm sure all of you are really sad to not hear about, the mechanism does allow the company to true up, reaching back up to 5 years.
Okay.
And so there is definitely a difference in the language there. But for clarity of record, it isn't something that has never occurred across the dockets.
Okay. Thank you very much.
Just a couple of questions, and I guess the first goes back to this question of what's de minimis again. Because I thought I heard you indicate when Commissioner Kimmerite first asked you that question as to what would be de minimis. I thought you had said it was 5 million at that point in time. That would, anything above that would be a reason to come back in and seek some sort of true up if there was a shortage. Is that? But now I'm understanding you to say something different now, I believe.
I think it's fair to state that in the past, the amounts have been less than 5 million. And from the company's viewpoint, in those instances, those amounts we viewed as de minimis, and so we did not come in.
So the term de minimis, the way you are perceiving it, had nothing to do with the original magnitude of the amount of shortfall that might have been involved. Because I mean, in that case of 23, we had an unprecedented shortfall that was greater than any amount of shortfall that ever existed before. If you cumulatively totaled them all up, it was less than close to $1 billion.
Correct.
Was this de minimis within the context of $1 billion? If you were looking at the magnitude of the original shortfall, you were looking at.
Is the 8 million, is the question,
Yeah.
is the 8 million that we've,
Yeah.
the
Within
company is not,
context of
yeah,
the totality
Yeah.
of the shortfall you were looking at.
the company does not believe it's de minimis. And again, are projected to be further unrecovered. Ultimately, the fuel statute allows the company to recover fully for its prudent costs, dollar for dollar, and the company does not make money on its fuel costs.
And I guess the other question I had, if this was your interpretation or Duke's interpretation when the settlement agreement was entered into, is there some reason why language was not included in that particular stipulation or agreement that would have allowed for what you were seeking at this time? I mean, where you're looking apparently at the magnitude in determining that it's no longer de minimis, but it's greater, and you're entitled to come back and seek this EMF adjustment? Is there some reason why language that recognized that, particularly since it was unprecedented in the context of other cases involving the fuel clause? What, is there some reason why that language wasn't there?
Commissioner, because you're highlighting a best practice going forward to include such language. But from the company's perspective, they entered the agreement with the intent to fully recover the 998. The 998 million was never in dispute. Whether those costs were prudently incurred was never in dispute. The commission acknowledged that that was the correct fuel balance in its order and acknowledged that it was a significant under recovery. And the rate that was designed to recover $998 million. And so the rate was designed to recover. The intent was to recover that amount through that rate over the 16-month recovery period. And so that customers will receive a reduction in their bill impacts. And the customers are experiencing a reduced percentage in their bill impacts. And what's undisputed is that the company is under recovered on that 2023 EMF balance to, as I've noted, $8 million with a projected under recovery by year end. And so the intent was always for the company to recover the amount. There's also no term that says the company will write off an amount in the agreement. The mitigation strategy that the public staff and the company entered into was to mitigate bill impacts by extending the recovery period, but to set a rate to recover. This section 3 of this settlement says the fuel balance will be recovered, not may be recovered, not in Mr. Freeman's words, we hope that it be recovered, but that it will be recovered. And we understand it was a unique and unusual large balance, but it's not unreasonable, rather it is reasonable for the company to expect to recover its prudently incurred fuel costs.
And I guess the last question is, based upon your interpretation of the statute and the interpretation of the statute by the public staff, I think it'd be fair to say there's ambiguity at this time. Is there a reason why that ambiguity should not be addressed by the General Assembly to provide some clarity as to the purpose, intent, and what should be recovered? As I mean, we're asked to do it now, and I'm sure that we will within the confines of our decision making. But at the same time, I mean, since they are the ones that wrote the statute, and it appears now as if, even though there was not in the past this ambiguity that has now emerged, is there a reason why they should not be looked upon to clarify it?
So when the General Assembly statutorily confirms the EMF, it expressly stated that the EMF was enacted in order for the commission to recover its reasonable costs, including the fuel component of the purchase power, with no over recovery or under recovery in a manner that serves the public interest. So it would seem that the General Assembly was intentional in expressly stating in Section 2 of Senate Bill 524 that the intent in the enactment of this act shall be construed as clarifying rather than changing the meaning of General Statute 62-133.2 as it was previously worded and as it was construed by the Utilities Commission and Commission Rule R855, so that utilities will recover only their reasonable fuel expenses prudently incurred, including the fuel cost component of the purchase power, with no over recovery or under recovery, in a manner that would serve the public interest. And I would submit that the General Assembly was expressly direct with their intent in statutorily confirming the EMF, and the company being able to recover its prudent costs is in the interest of the in the interest of the public and that this commission is required to regulate utility in a manner that's fair to the commission, to the customers, as well as to the utility. And the utility being made whole on its prudent cost is fair to the utility and ultimately fair to the customers as well.
And with that statutory language being what it says, in the past, the way this has been interpreted and carried out as a matter of practice, there's not been an occasion where you've come in a second time to seek a EMF factor adjustment. And I gather now it is because it's no longer de minimis.
Yes. So, yes, the magnitude of the under recovery is almost $1 billion. And so while the company, Duke Energy Carolinas, has not come in previously, Dominion did come in and request a mitigation strategy that allowed it to true up its EMF, which required the utility to set an EMF rate, which was approved by the commission, that reaches back multiple years to recover a component of previously incurred fuel costs in a previous test period, and to carry it forward and set an EMF increment in order to recover test year application costs as well as prior test year prudently incurred costs.
I don't have any other questions at this time.
Commissioner Tucker.
Thank you, Commissioner. Just one quick question. If Duke is not allowed to recover the under recovery, whether it be 8 or the $17 million cost, it's a possibility that that will show up in a future rate case to recover those funds?
Not without permission from the commission.
That looks like that's all the questions from the commission. So I want to thank both attorneys for your excellent presentations on oral argument, and we will conclude the oral argument phase of this proceeding. So now we'll get started with the evidentiary case, beginning with the applicant.
One moment, Commissioner Cameron, I apologize.
Commissioner, if I may, during this break, the 4 documents I want to cite just clearly. I cited section 62-133.2, E100 sub 47, the order from August 14th, 1986, session law 1987-677, and E2 sub 833, the order from September 25th, 2003. I can't remember if I said those during my argument. I meant to, but I may not have.
And are you requesting they be moved into the record at this time?
I think so. I know there are statutes and rules that already exist, but I would think.
Okay. Over an abundance of caution, why don't you move it into the record, and then I will admit it into the record.
Thank you. I would move those 4 documents that I just identified and which I've handed out to the people in the room into the record, please.
Your motion is allowed.
Thank you.
And Commissioner Cameron, would this be the appropriate time to request that those witnesses that were excused in the commission's June 7th order, that their testimony exhibits be moved into the record along with the affidavits?
Yeah, so we can hear motions from the attorneys for all of the witnesses who have been excused with their testimony and exhibits at this time, beginning with the applicant.
Yeah. So moved, Commissioner.
Okay.
Right.
Your motion is allowed. So that we can go ahead and have the record completed, let's go ahead and hear from all the parties in regard to the witnesses who have been excused and the exhibits.
Thank you, Commissioner. The public staff pre-filed the testimony of public staff witness Daryl Brown on May 23rd, 2024, consisted of 10 pages of testimony and an Appendix A consisting of 1 page. There were no exhibits. I respectfully ask and move that Mr. Brown's testimony, including the appendix, be entered into evidence and the record as if orally given from the stand.
Okay. Your motion is allowed.
Thank you. The next and last motion is the public staff pre-filed the testimony of public staff witness Evan Lawrence on May 23rd, 2024. It consisted of 15 pages of testimony and an Appendix A consisting of 1 page. It also included Exhibit 1, which consisted of 2 pages. I would respectfully ask and move that Mr. Lawrence's testimony, including the appendix, be entered into evidence and entered into the record as if orally given from the stand, and further ask that Mr. Lawrence's Exhibit 1 be marked in the manner in which it was marked when it was filed, and also entered into evidence and the record.
Your motion is allowed.
Thank you.
Matt Tynan for CUCA. CUCA filed the direct testimony of Jonathan Lee on May 23rd, 2024, consisting of 5 pages of testimony, 2 appendices, and 2 exhibits. CUCA would move this testimony be entered into the record as if given orally from the stand today, and that the corresponding exhibits and appendices be entered into evidence as pre-marked.
And can you confirm that Mr. Lee's testimony was 5 pages rather than 8 pages so that we can be clear for the record?
I believe it was 5 pages, and then the appendices continued the pagination of the testimony.
Okay. Your motion is allowed.
Good afternoon, Christina Kress for SIG for 3. On May 23rd, 2024, SIG for 3 caused to be filed in this proceeding the pre-filed direct testimony of witness Brian C. Collins, consisting of 12 pages of testimony, 1 appendix pre-marked as Appendix A, consisting of 4 pages, and a certificate of service, as well as 1 exhibit pre-marked as BCC 1. And at this time, SIG for 3 would request that the testimony be admitted into the record as if given orally from the stand, and that the appendix and exhibit filed with witness Collins' direct testimony be admitted into the record and identified as pre-marked.
Okay. Ms. Kress, is portions of witness Collins' testimony confidential?
Yes.
Okay, so we will admit it both in a confidential form and also in a non-confidential form.
Thank you very much.
Okay. And Ms. Toon, for clarification for the record, for your excused witnesses, this is the information that I have. Witness Matthew Cameron for his direct testimony filed on February 27th of 2024, consisting of 9 pages and 2 exhibits. Witness Stephen Capps provided direct testimony, portions of which were confidential version, on February 27th of 2024, consisting of 14 pages and 1 exhibit. Rebuttal testimony filed on June the 3rd of 2024, consisting of 2 pages. Witness Flanagan, direct testimony filed on February 27th of 2024, consisting of 12 pages. Witness McNeil, direct testimony filed on February the 27th of 2024, consisting of 9 pages. Witness Suez, direct testimony, portions of which are marked confidential, filed on February 27th of 2024, consisting of 13 pages and 3 exhibits, and rebuttal testimony filed on June the 3rd of 2024, consisting of 3 pages. That is my understanding of your motion. Is that correct?
That is correct. And
Okay.
I apologize for not listing that out for you, Commissioner Cameron.
Your motion is allowed.
Thank you.
Okay, with that, would you call your witnesses?
Yes, and with your permission, the company will put up its direct and rebuttal testimony as a panel. That's okay? Okay. So at this time, we'll now call Mr. Gurney Clark and Mr. Brian Sykes to the stand. Please watch your step. And if you could remember. We can pull their mics up.
You may proceed.
This one.
Oh, excuse me. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you.
Starting with Ms. Clark, please. Yes, pull your mic close. Would you please state your name and business address for the record?
Yes. Good morning, Commissioners. My name is Sigourney Clark. My business address is 5413 Sharon Harris Road, New Hill, North Carolina.
By whom are you employed and in what capacity?
I am a Rates and Regulatory Strategy Manager for Duke Energy Carolinas.
Did you cause to be profiled at this docket on February 27th, 2024, 16 pages of direct testimony, 7 exhibits, and 12 work papers.
Yes, I did.
Do you have any changes or corrections to your direct testimony?
No, I do not.
And did you also cause to be pre-filed on this docket on May 8th, 2024, 12 pages of supplemental direct testimony, 7 exhibits, 4 of which were revised exhibits, and 12 work papers, 1 of which was revised?
Yes, I did.
Do you have any changes or corrections to your supplemental direct testimony or exhibits?
No, I do not.
Did you also cause to be profiled in this docket on January 3rd, 2024, 24 pages of joint rebuttal testimony?
Yes, I did.
And did that rebuttal testimony accompany 8 rebuttal exhibits and 12 work papers?
Yes. And when taken together with my revised rebuttal exhibits filed on June 6, 2024.
With respect to your revised rebuttal, did you cause to be pre-filed in this docket on June 6th for revised rebuttal exhibits?
Yes.
And when taken together with your revised rebuttal exhibits filed on June 6th, do you have any changes or corrections to your rebuttal testimony?
No, I do not.
If I were to ask you the same questions that appear in your direct, supplemental direct, and joint rebuttal testimony today, would your answers be the same?
Yes, they would.
And have you prepared a summary of your testimony for the commission?
Yes, I have.
Unless Commissioner Camwright would prefer Ms. Clark read the summary, I will move that it be moved into evidence along with her other exhibits at this time.
Yes, we will not hear the summaries be read into the record. Thank you.
I move that Ms. Clark's pre-filed direct, supplemental direct, and joint rebuttal testimony, as well as the summary of her testimony, be copied into the record as if orally given from the stand. And I also move that Ms. Clark's exhibits and work papers submitted with her direct, supplemental, and joint rebuttal testimony, including revised exhibits, be marked as identification as pre-filed. Now turning to Mr. Sykes, would you please state your name and business address for the record?
Yes. Good afternoon, Commissioners. My name is Brian L. Fikes, and my business address is 525 South Tryon Street in Charlotte, North Carolina, 28202.
By whom are you employed and in what capacity?
I'm employed by the company as a Director of Rates and Regulatory Planning, overseeing numerous annual rider proceedings for both Duke Energy Carolinas and Duke Energy Progress, including the annual fuel adjustment rider.
Did you cause to be pre-filed in this docket on June 3rd, 2024, 20 pages of joint rebuttal testimony along with Mrs. Clark?
24 pages, yes, I did.
Did you submit 2 exhibits, including confidential exhibit 2, along with your rebuttal testimony?
Yes.
Do you have any changes or corrections to your rebuttal testimony or exhibits?
No.
If I were to ask you the same questions that appear in your rebuttal testimony today, would your answers be the same?
Yes.
Commissioner Camwright, at this time, I move Mr. Sykes' pre-filed rebuttal as well as his 2 exhibits be copied into the record as if orally given from the stand. Thank you, Commissioner Camwright. I also move that Mr. Sykes' 2 exhibits be pre-marked as an identification as previously filed. At this time, the witnesses are available for cross-examination and commissioner questions.
Thank you, Commissioner. The public staff has no questions.
Okay. Are there any questions for from CUCA?
No, Commissioner.
Any questions from SIGFR?
No questions.
Okay. So I have just a couple of questions. I believe in testimony you stated that for the $8 million under recovery amount, that DEC is not seeking to recover the carrying costs. Is that correct?
That is correct.
Okay. I don't believe that your testimony said anything about the additional amount that is projected to increase to $17 million. Is the company's position the same for the carrying costs for any additional amount that may be increased?
That's correct. No additional carrying costs on whatever the under recovery or over recovery happens to be.
Okay, thank you. And then can you spend just a minute talking about the proposed industrial mitigant described in the stipulation for the record so that we can have an understanding of the stipulation?
Absolutely. So if you remember from direct, we were faced with the under recovery of $998 million from the prior year. That coupled with the fuel costs that we are seeking recovery of this year. The stipulation that we entered into last year recovered that $998 million over a period of 16 months. Therefore, there will be a period of 4 months, September of this year through December of this year, where 2 fuel rates would be in effect. That had a pronounced impact on the industrial customer bills due to the elimination of the equal percent methodology, which this commission ordered the company to eliminate beginning with the 2024 fuel rider. So our industrial customers were going to face a temporary increase of almost 9% on September 1st, followed by a bill decrease of almost 16% on January 1st. So after we made the direct filing, we met multiple times with SIGFR and CUCA to talk about what the company could do to help them out, given that pronounced bill impact. And so fast forward to within the last few weeks, we met again with SIGFR and CUCA and readdress what they had put in their direct testimony, which is a mitigant that would take their bill impact on September 1st down to 0%. So thankfully, the company was able to meet that request. And so in settlement that we reached on Friday, we did agree to take their fuel costs and defer them to January 1st of 2025, such that they will be paying the majority of the fuel bill for the 8-month period, January through August of next year. And so at the end of that 0% bill increase on September 1st, followed by a 0.6% bill decrease on January 1st.
Okay. Thank you. And for the record, can you confirm that the stipulated mitigant will not adversely affect any other rate class?
Yes, I can confirm. No other rate class will be impacted by the settlement.
And also for the record, can you provide your opinion about whether the stipulation is in the public interest?
I would say it's absolutely in the public interest. SIGFR and CUCA came to us and said, can you do something additional? And so the company was able to do that. I will say one condition of the settlement is that the commission find it appropriate for the company to revisit the $998 million from the 2023 settlement.
Okay, thank you. Are there any questions from the commission? Chair Mitchell.
Good afternoon. Just a few questions for you all. Do you have your rebuttal testimony in front of you?
I do.
Okay, I'm looking at page 12. Page 12, and then beginning around line 5, there's a paragraph that discusses load forecast. Do you see where I am?
I am.
Okay, so as I understand your testimony there, you're describing the 16-month period for the settlement agreement that you previously entered into with the public staff that the commission approved, and you testify that the company's because the company didn't have 16 months of normalized sales data over which to recover the $998 million balance. Can you help me? Can you talk some more about that or explain some more about that issue? I mean, you know, your request related to truing up the EMF relates to the fact that you've under recovered, and some of that is because these projections were off. But talk about having 12 months versus 16 months of normalized data.
So in a normal test period, when we're here before you on an annual basis, we're looking at a 12-month calendar year. And typically following Commission Rule R8-55, we will take the under recovery by customer class and allocate that over each customer class's normalized test period sales. So in those normalized test period sales, we are removing the impacts of weather and customer growth, either adding them or subtracting them depending on what happened during that test period. As you mentioned, when we entered into a settlement last year, we entered it to recover that balance over 16 months instead of 12. So we didn't have a good denominator, if you will, to use with normalized test period sales for a 16-month period. What we did have at that point in time was a new forecast. You remember we also updated our proposed fuel cost to a more current fuel forecast in last year's proceeding. And so we did have 16 months worth of projected period sales to use. So in lieu of normalized test period sales, we elected to use the most current 16-month fuel or 16-month load forecast we did have available at the time. So it's just a matter of not having 16 months worth of normalized test period sales for the recovery period.
Okay. As I understand thank you for that explanation. As I understand the testimony in this case, you're under recovered by approximately $8 million as of March 31? March 31, 2024. Where does that under recovery sit today?
It's a great question. So I did look at it for the month ended May, and while we haven't filed monthly data through May with the commission yet, it really hasn't moved that much. So I would say it's 8.1 or $8.2 million, if I recall correctly. So it really hasn't moved much in the last 2 months.
Okay, so you've included exhibits with your testimony that project the under recovery out through the end of this year, and you get to 17 million approximately. What were those projections based on? Like, what assumptions, let me ask the question a different way. What assumptions were you making to get to that amount of under recovery?
So we're looking at the total 16-month recovery period. So we have actual data that support this first 7 months through March 31st of 2024. What we are looking at for April through December is our most current load forecast.
Okay, so it's a load forecast that's different from the 2023 spring.
That is correct.
Okay, it's okay. All right. Let me see. So one more question about the 12 months versus 16 months. Let's say you all hadn't entered into the mitigation settlement, the 16-month settlement, and y'all had sought to recover over 12 months. Your attorney provided some information that the assumption was that you would be 4 million under collected at this point in time. Is that consistent with your understanding?
It is. Through March 31st of this year, instead of the 8 million, it would be approximately 4 million.
Okay. Okay. All right. Okay, I have nothing further. Thank you.
It does not appear that there's any further questions for the commission. So thank you for your testimony, and you may be excused. Ms. Toon, I believe that the agreement and stipulation of settlement that was filed on June 7th, 2024, we need to have a motion for that.
Yes, Commissioner Cameron, the company moves that the agreement and stipulation of settlement filed in this docket on June 7th, 2024 be moved into the record.
Your motion is allowed.
Yes, Commissioner Cameron, I'd also like to make a motion that the company's application be moved into the record.
Okay, your motion is allowed.
Thank you.
Okay. Anything further?
Nothing
Okay.
further.
Okay, then the witnesses may be excused. So we'll turn it over to the public staff for their case now.
Thank you, Commissioner. At this time, Commissioner, I would call Mr. McLawhorn and Ms. Boswell to the stand.
Good afternoon. If you can place your left hand on the Bible and raise your right hands, do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Thank you. Mr. McLawhorn, if you would please state your name and business address for the record.
James McLawhorn. I'm the Director of the Public Staff's Energy Division, and my business address is 430 North Salisbury Street, Raleigh.
And please tell us by whom you are employed and what you do.
I am employed by the North Carolina Public Staff.
And Ms. Boswell, would you please state your name, business address, employer, and job title?
Sure. Michelle Boswell. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I am the Director of the Accounting Division with the Public Staff employed by the state of North Carolina.
Thank you. On May 23rd, 2024, did both of you cause to be pre-filed in this docket joint testimony consisting of 14 pages of testimony, which also included Appendix A, consisting of 1 page setting forth the qualifications and experience of Mr. McLawhorn, and Appendix B, consisting of 2 pages setting forth the qualifications and experience of Ms. Boswell?
Yes.
Do you, do either of you have any changes or corrections to your pre-filed joint testimony?
No.
If I were to ask you the same questions today under oath, would both of you give the same answers as set forth in your pre-filed joint testimony?
Yes.
Yes.
Commissioner Kimmerer, at this time, I would respectfully ask and move that the joint pre-filed testimony of Mr. McLawhorn and Ms. Boswell be entered into the record as if given orally from the stand here today.
Your motion is allowed.
Thank you. Commissioner, the joint panel is now available for cross-examination and commission questions.
Thank you.
No questions from the company.
No questions from CUCA.
No questions from SIGFR.
So I do have a couple of questions for you. Either Ms. Boswell or Mr. McLawhorn, whoever is best to answer the questions. Starting with the about $8 million under recovery amount that's being projected to potentially increase to about $17 million. If the situation were the reverse and that DEC was over recovering $8 million or potentially over recovering $17 million, what would the public staff's position would be if the situation were the reverse?
It would be exactly the same. The statute and the commission rules and more than 37 years of case history and commission rulings speak for themselves. I mean, there is no true up of the true up.
Anything to add, Ms. Boswell, or are you in agreement?
I agree.
And then I want to talk specifically about the $8 million under recovery amount from, I believe it's from September the 1st of 2023 through March the 31st of 2024. Can you state or confirm that the public staff's position about whether those costs were prudently incurred? Is there any dispute about whether they were prudently incurred?
The $998 million under recovery experienced in sub 1282 was deemed to be prudently incurred and properly accounted for. So therefore, we don't have issue with the $998 million in cost. Regarding the $8 million that the company has calculated, the public staff has not reviewed their calculations to determine the validity as to whether or not they've actually incurred those.
Okay. The public staff has not had the opportunity.
Correct.
To provide that analysis. Is that correct?
Yes, ma'am.
Okay. And then on page 14 of your testimony, you express the concern that the under recovery is based upon partial data and that the actual results could change. But in this proceeding, we don't know what the commission is going to do with this request, but Duke is committed to return any over recovery to the customers. Would that solution address your concern about partial data and the public staff not having the opportunity to determine whether those costs are actual and whether the under recovery was prudently incurred? Whether the costs were prudently incurred.
I don't believe it does, just simply because based on the advice of counsel, we don't believe that there's merit to the argument to begin with. But putting that aside for a moment, what the company is essentially asking for is we forecasted once and we didn't get it right. And we're forecasting it again, but trust us on this forecast because we got this one right.
But I believe the testimony of the company witnesses also say, but just in the off chance that we don't get it right this time, we'll come back and we'll try again, and presumably try again and try again. So it's kind of like a dog chasing its tail. You're never going to catch it. We're never going to exactly zero out these costs, no matter how many true ups we do.
So setting aside the legal argument, putting that aside, but if Duke were, or DEC were to have at this point from the true up and over recovery, they've committed to reimbursing it to the customers. Would there be harm to the customers if there was an over recovery that was then reimbursed to customers? Help me to understand what harm, forgetting about the legal argument, what harm could there be to customers?
If the over collection was refunded to ratepayers, I don't know that it would have to include interest on it. And I don't know that we would take issue with it so long as it's made for sure that every dollar and every cent is recovered or sent back to ratepayers, just like the company has requested that it get every dollar and every cent.
Okay.
But if that could not be done in one true up, then it would only be right to continue to true that amount up.
Mm-hmm. So moving on to the stipulation that was filed, and in the stipulation, it relies upon DEC's proposed new EMF factor, which is the proposed mechanism to collect the approximately $8 million under recovery from the 2023-2024 rate year EMF. Other than the EMF, does the public staff have any concerns about the proposed industrial mitigant?
You're talking about the stipulation that was filed this past Friday.
That is correct.
Okay. Well, I think first of all, the public staff was not a party to that stipulation. We did not sign it. I think we were generally aware that there was potential for stipulation to be filed. I was not involved and had not seen any of the wording in advance. We had heard general concepts about it, but I think my understanding of the stipulation is that it is tied to the commission granting the true up of the true up, and that's problematic.
You are correct about that, but with the exception of it being related to or tied to the commission granting the EMF, do you have any other concerns about the stipulation? We want to understand if the public staff has a position about the stipulation outside of the EMF that's proposed.
As a general rule, and I'll get to your specific question, but as a general rule, if the company wants to voluntarily enter into a stipulation with public staff or with SIGFR or CUCA or with both of them, as long as it does not negatively impact other customer classes that aren't represented, we don't generally have a problem with that. I would note, though, that in this particular case, SIGFR and CUCA do not represent all industrial customers of DEC. They represent some very large industrial customers, but that's not all industrial customers. So not all customers that would be impacted were a party to this stipulation.
And just to make sure that I'm clear, does the public staff have any concerns about the stipulation adversely affecting any other customer classes? Have you had a chance to consider that?
With the inclusion of the EMF, yes, we do have concerns that it affects other rate classes. In and of itself, outside of the EMF, no. However, as Mr. McClawhorn just stated, since they don't represent all industrial customers, it represents an issue within that class itself.
Okay.
Presumably, it is a benefit to the SIGFR and CUCA customers, and I don't have any reason to believe that from that standpoint, it would not be beneficial to other industrial customers. But of course, they're not all on the same rate schedule. I don't know that that would make a difference in this case, but we haven't analyzed that.
Okay, thank you. Any questions from the commission? Chair Mitchell.
Okay, just a few for y'all. Mr. McLaughlin, you mentioned just a minute ago, 37 years of history, this has never been done. And you all have expressed concern, like I heard from your counsel during his argument about a true up of a true up, sort of that getting into that unending cycle of having to true up. But you heard Duke's counsel discuss the Dominion case where there was the 2-year settlement. Were either of y'all involved in that proceeding?
Yes, we
And-
were.
And so in that case, and this is how I understand it, make sure I've got it right. There was there was an agreement between the public staff and the utility to recover over a 2-year period. And the settlement agreement involved a term that allowed Dominion to seek a true up for any unrecovered amounts at the end of that 2 years. Do I have it right?
Yes.
Okay. And so do you remember how Dominion how did Dominion true up? Was it a one-time true up? I mean, how did they achieve an actual true up?
If memory serves and subject to check, it was a one-time true-up.
So was it, and was it just, how was that one-time true up charged to customers? If you don't remember, that's okay.
I don't remember.
Okay, that's fine.
I do know that as part of that settlement, Dominion did not collect interest for the spread, so they took on some considerable risk. And it was also, this was, if I'm recalling correctly, and correct me if I'm not, Ms. Boswell, but Dominion brought that proposal forward with their filing. In the 1282 case, DEC did not propose any mitigation. That only came about during the course of the investigation, only was for 4 months, and they asked for the interest on it.
Well, and their request came about in the course of the investigation in the present case, not in the sub 1282 case.
I was talking about the original.
Yeah, I follow both of you there. I follow both of you. Okay. Okay. And so you pointed out, Mr. McLaughlin, the interest, the distinction between the Dominion case and the Duke situation is that Duke's recovering interest and Dominion did not. But in the Dominion case, the public staff agreed to this idea of a true up. And I guess I'm wondering if Duke had brought, if Duke, would the public staff have agreed to a true up in this case, had it been negotiated, when y'all were negotiating the settlement for this $998 million?
In the 1282
Yes.
case. It's impossible to say. We certainly would have considered it had it been brought forward up front. I think it's important to remember that I believe the Dominion spread was over 2 years without interest, whereas Duke was only willing to go an additional 4 months with interest. So as with any settlement, and I know the commission is aware of this, you have to take all factors into consideration, but I don't think the public staff would have rejected it out of hand.
Okay. Okay, that's a fair answer. What, okay. Mr. McLaughlin, the 900, we started a fuel case proceeding ago with a $998 million of unrecovered expense. And there was y'all have already confirmed that there was no dispute with that $998 million. Am I correct there? I know.
That's correct. There
Okay.
was an outage, as I'm sure you
Okay.
remember, held over, but we did not find any.
Okay.
So there was no imprudence identified.
Okay, I'll make sure the record is clear on your position because I don't want to misstate it. So, no imprudence identified. Okay. Would it have been the public staff's position at that time, or was it the public staff's position at that time that the company was entitled to recover that amount?
It was entitled to an opportunity to
no,
recover
okay.
that amount.
I'm
Yes.
sorry, and I interrupted you. You want to say that again for the record?
Our understanding is that the company was entitled to the opportunity to recover that amount, as they had been in every fuel case for the last 37 years when there was an over or under recovery.
Okay. Okay. Um, all right. Well, all right. I have nothing further. Thank you.
Commissioner Duffley.
Good afternoon. We heard today that if it had been 12 months and not 16 months, it would have been $4 million, not $8 million. And just, I'm wondering your thoughts on that. Is there any significance to those numbers, in your opinion?
No. But like I said, we haven't audited or reviewed their calculations, so we don't really have a parameter if the 8 million is accurate or not, so no.
And at the risk of doing math in my head on the stand, I've been thinking about that. And I would have to go back and look at it, but had there not been mitigation, the rate would have been higher than it was. And if the sales were the same, it seems that the under recovery would have been greater at this point, but I may be missing something.
Okay, thank you for that.
Chair Mitchell.
Yes, just one question, Ms. Bosworth. Did you, I mean, Ms. Bosworth, did you, y'all haven't audited the 8 million under recovery?
No.
Okay, so is it your concern that there is no under recovery?
I don't know that it's our concern that there is no under recovery. We just, in the 37 years since the rule came about, have never gone back to look to see if the company over or under, just because the plain language as our council dictated didn't allow for it. And so when it was brought forth to us at the late hour that it was, there wasn't time, nor was there, was there an audit in place where we had done that before?
Okay, so I mean, we've heard today about previous cases where there has been an over recovery or an under recovery. Is it the case that in those instances, the public staff didn't go back and verify the amount of the over recovery or the under recovery?
We did not.
Okay.
Since there was nothing that could be done about it, it would have required, as Commissioner McKissick correctly pointed out, it would have required, in our understanding and belief, it would have required a legislative change.
Okay. Okay, thank you.
Okay, thank you. So questions on commission questions?
No questions.
Okay.
Pardon me, 1 minute, Commissioner. Just a quick clarifying question. The cumulative variance between anticipated versus received funds for the sub 1282 under recovery through December 31st, 2023 was $96,353. And most of the $8.1 million at issue came in January, February, and March of this year. Correct?
That is what the company has put forth, yes.
Okay, thank you.
Thank you. Any motions from the public staff?
Yes, thank you, Commissioner. I don't believe we had any exhibits, but I would move the testimony of, Mr.
I believe it's joint direct
The joint direct
testimony.
testimony of Mr. McLaughlin and Ms. Boswell into the record, including appendices A and B.
Right. I believe it's consisting of 14 pages with 2 appendices, and your motion is allowed.
Thank you very much thank you.
Okay. Mr. McLaughlin and Ms. Boswell, thank you for your testimony. You may be excused.
Thank you.
I think this brings us to the end of the witnesses and the evidentiary hearing. Are there any additional matters that need to be addressed, beginning with Duke?
None.
Any matters from the public staff?
No, thank you. No, Commissioner, thank you.
Okay. Okay, so thank you to everyone. We've now concluded the expert witness hearing. Proposed orders will be due 30 days from the notice of the mailing of the transcript. And with that, the hearing is concluded and we'll go off the record and we will take a 10-minute break and come back at 4:10.
Thank you.
Good afternoon. Let's come to order and please go on the record. I'm Commissioner Kimberly W. Duffley, and with me are Chair Charlotte A. Mitchell and Commissioners Jeffrey A. Hughes, Floyd B. McKissick Jr., Karen M. Kimmerite, William Brawley, and Tommy Tucker. I now call for hearing docket number E7 sub 1305, which is the application of Duke Energy Carolinas LLC, hereinafter DEC, for approval of demand-side management, hereinafter DSM, and energy efficiency, hereinafter EE, cost recovery rider pursuant to North Carolina General Statute Section 62-133.9 and Commission Rule R8-69. In compliance with the State Government Ethics Act, I remind the members of the Commission of our responsibility to avoid conflicts of interest, and I inquire whether any member has a known conflict of interest with respect to the matter before us in this proceeding. Please let the record reflect that no conflicts have been identified. Section 62-133.9 of the North Carolina General Statutes establishes the procedure for cost recovery of DSM and EE expenditures. Section 62-133.9D provides for an annual DSM-EE rider for electric public utilities to recover all reasonable and prudent costs incurred and appropriate incentives for adoption and implementation of new DSM and EE measures. On February 27th, 2024, DEC filed its application for approval of the DSM-EE cost recovery rider, along with the testimony and exhibits of Caroline T. Miller and Casey Q. Fields supporting the application. Carolina Utility Customers Association Incorporated and Carolina Industrial Group for Fair Rate Utility Rates 3 filed petitions for intervention, which were granted by the Commission. The public staff, which represents the using and consuming public, has been made a party to this case pursuant to North Carolina General Statute Section 62-15. On May 15th, 2024, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and requiring public notice. On May 8th, 2024, DEC filed the supplemental testimony and revised exhibits of Caroline T. Miller and Casey Q. Fields. On May 20th, 2024, the public staff filed the direct testimony of David M. Williamson and the joint direct testimony of Hemeth Mehta and Michelle Boswell. On May 29th, 2024, DEC filed the rebuttal testimony and exhibits of Caroline T. Miller. On May 31st, 2024, DEC filed the required affidavits of public notice. I now call for the appearances of counsel, beginning with the applicant.
Good afternoon again, Commission. LaDawn Toon on behalf of Duke Energy Carolinas.
My name is Will Middleton with the law firm of Baker Donaldson here on behalf of Duke Energy Carolinas.
Welcome.
Thank you.
Good afternoon, Commissioners. My name is Ann Keyworth. I am here on behalf of the using and consuming public with the public staff, and with me today is Nadia Laura.
Thank you.
Good afternoon, Matt Tynan with the Brooks Pierce Law Firm for CUCA.
Good afternoon.
Good afternoon, Christina Kress with the law firm of Bailey and Dixon here on behalf of SIGFR 3.
Good afternoon. So with respect to the public witness hearing, Ms. Keyworth, have you identified anyone present and wishing to provide public witness testimony in this docket?
No, Commissioner Duffley, we have not.
Out of an abundance of caution, is there anyone in the hearing room that wishes to provide public witness testimony? Okay, hearing none, we'll move on to the expert witness portion of the hearing. Are there any preliminary matters we need to address prior to the hearing?
None from the company.
Okay, so let's proceed. DEC, if you'll call your first witness or panel.
Yes, Presiding Commissioner Duffley, with your permission, the companies would like to call Ms. Miller and Mr. Fields as a panel to address both the direct and rebuttal case of the company.
Okay, and you're doing the direct, supplemental, and rebuttal all at one time?
If allowed, that's correct.
Yes, that is allowed. There's no objection.
Thank you, Presiding Commissioner Duffley. Then the company will now call Carolyn T. Miller and Casey Q. Fields to the stand.
Good afternoon. Unless you say you want to be affirmed, I'll swear you. If you could place your left hand on the Bible and raise your right hand, do you solemnly swear that the testimony you will provide this afternoon will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you very much. Start with you, Ms. Miller. Would you please state your name and business address for the record?
My name is Carolyn T. Miller, and my business address is 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I am a Rates and Regulatory Strategy Manager for Duke Energy Carolinas LLC, supporting both Duke Energy Carolinas and Duke Energy Progress.
Okay, and Ms. Miller, did you cause to be pre-filed in this docket on February 27th, 2024, 23 pages of direct testimony and 7 exhibits?
Yes.
Thank you. Do you have any changes or corrections to that direct testimony?
No.
And did you also cause to be pre-filed in this docket on May 8th, 2024, 6 pages of supplemental direct testimony and 4 revised exhibits?
Yes.
Thank you. Do you have any changes or corrections to your supplemental direct testimony or exhibits?
No.
Okay. And did you also cause to be pre-filed in this docket on May 29th, 2024, 19 pages of rebuttal testimony and 2 exhibits?
Yes.
Do you have any changes or corrections to your rebuttal testimony or exhibits?
No.
And Ms. Miller, if I were to ask you the same questions that appear in your direct, supplemental direct, and rebuttal testimony today, would your answers be the same?
Yes.
And have you also prepared a summary of your testimony for the commission?
Yes.
And Presiding Commissioner Duffley, I'd request that that summary be moved into the record rather than read from the stand, if that's okay.
That is approved.
Thank you. And Presiding Commissioner Duffley, with that, I also move that Ms. Miller's pre-filed direct, supplemental direct, and rebuttal testimony, as well as the 7 exhibits submitted to her direct, 4 revised exhibits submitted with her supplemental direct, and 2 rebuttal exhibits be marked for identification as pre-filed.
That motion is allowed.
Thank you. Mr. Fields, we'll turn to you now. Would you please state your name and business address for the record?
Yes, my name is KCQ Fields and my business address is 411 Fayetteville Street, Raleigh, North Carolina.
Okay, and by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services as a lead strategy and collaboration manager for the Carolinas and our customer solutions regulatory enablement group.
Okay, and did you cause to be pre-filed in this docket on February 27th, 2024, 31 pages of direct testimony and 24 exhibits?
Yes.
Okay, and do you have any changes or correction to your direct testimony or exhibits?
No.
And did you also cause to be pre-filed in this docket on May 8th, 2024, 3 pages of supplemental direct testimony and 1 revised exhibit?
Yes.
And do you have any changes or corrections to your supplemental direct testimony or exhibit?
No.
If I were to ask you the same questions that appear in your direct and your supplemental direct testimony today, would your answers be the same?
Yes.
And Mr. Fields, have you also prepared a summary of your testimony for the commission?
Yes.
Presiding Commissioner Duffley, I'd request that that summary be moved into the record rather than read aloud from the stand.
That motion's allowed.
Thank you, Presiding Commissioner Duffley. And then I'd also move that Mr. Fields' pre-filed direct and supplemental direct testimony, as well as the 24 exhibits filed with his direct and 1 revised exhibit filed with his supplemental direct, be marked for identification as pre-filed and moved into the record.
So with respect to Mr. Fields' direct and supplemental testimony, that is going to be entered into the record as if given orally from the stand, and the exhibits will be marked as they were pre-filed. And with respect to Carolyn Miller's direct, supplemental, and rebuttal testimony, those testimonies will be entered into the record at this time as if given orally from the stands, and the corresponding exhibits will be marked for identification at this time.
Thank you, Presiding Commissioner Duffley. And with that, the company's witnesses are available for cross-examination and questions from the commission.
No questions, no cross-examination
We do
questions.
have just a few. Thank you, Presiding Commissioner Duffley. Ms. Miller, we have just a few questions for you today on the topic of net loss revenues.
Okay.
If you'll, just to orient you and the commission, if you recall, the public staff asked in its direct testimony that the company provide verification in its rebuttal testimony, demonstrating that the company's methodology of calculating net loss revenues did not result in double counting. Is that correct? Is that your recollection of
That is
what
my
we-
recollection.
of what the public staff alleged in or requested in testimony?
That is correct.
Okay, thank you. So generally speaking, the is it correct that the EMV determines the kilowatt hour reduction per participant per measure over time? Is that correct?
That is correct.
Okay. And in order to calculate net loss revenues for a given measure in a month, is it correct that you're taking the number of participants times the kilowatt hour savings from the EM&V, and then again times the retail rate that's effective for that month? Is that accurate?
The rate that is used is not the retail rate. It is purely the rate recovering your fixed costs.
Okay, thank you for the clarification. So presumably the company knows the rates effective for any given month for the calendar year that include the base rate and the rider. Is that right?
We calculate the net lost revenue rate when we do our filing, and we look at on a historical basis, and we take the rates that are in effect for each month and back out fuel and other variable costs. And so we know on a historical basis what those are, and we use that same amount on a prospective basis as an estimate subject to true up.
Okay, so in any given month though, the company knows the rates effective that it's utilizing for its calculation.
Yes.
Yes. Okay. And does the company have verification of the number of participants for each measure within 1 or 2 months typically?
I might have to.
There could be some nuances with when we
Sure.
get participation in from a participant that really participated in January versus later on in the year. An example of that is our weatherization program, where we work with community action agencies. They may have someone that participated in January but didn't input an invoice or a request for an incentive until March, and so there would be some distance in there.
So it sounds like a couple of months typically is going to cover, the company's going to have verification of the participation within a couple of months. Generally, understanding that there might be exceptions.
Not without, going back and doing that for every one of the participants. It's hard for me to say for both the res and non-res that would be the case.
Okay. So given that for the most part, let me just back up for a minute. For purposes of net loss revenues, you identify participation for purposes of determining net loss revenues, right?
Yes, for net loss revenue purposes, the participation by month is assigned to each measure, and their actual savings per measure is then multiplied by the lost revenue rate to come up with a dollar amount that would be the net lost revenue amount requested in a rider.
So, and I guess my ultimate question is, if we have understanding Mr. Fields, the fact that, occasionally there's going to be participation that is not known for a bit longer than the couple of months, but generally, if this information is, known and actual, then why can't the company provide at least a ballpark verification as to why no double counting has occurred in its calculation of net loss revenues?
We believe that we have provided the underlying data necessary to verify that information. We have provided, as part of our work papers, the participants by measure times the rate for the test period, and shown how we have excluded that percentage from our rider. In addition, as part of the rate case, we have provided the billing determinants and the customer usage calculations for that test period to show the underlying assumptions reflecting the implicit inclusion of net lost revenues in the rate case.
But ultimately, what the companies are using in its calculation is an estimation for the participation.
No, I wouldn't agree with that because in our rider filing, we are looking at actual participation and actual measures and the rates associated with that. And when you look at the savings over the course of the test period, what the company is excluding is it's saying that over that period of time and that period of participation, this amount of savings has occurred. And in the test period of the rate case, you have that amount of savings implicitly included. And so we are, in effect, working in lockstep with the rate case to make sure that the assumptions in one are the same assumptions in the other.
I think that's all the questions we have now. Thank you.
Okay.
Redirect.
None from the company.
Okay, Commissioner questions? Okay, I have a quick question. So DEC's been using this methodology since the 2020 Commission mechanism order, correct?
It has actually gone back further than that. In our initial mechanism, and the rate cases back in, I believe, 2014, we've used this methodology back to that point in time as well.
Okay, and was this any type of change of this methodology discussed in the last DEC rate case?
It is not necessarily discussed in a rate case proceeding because net lost revenues are implicitly included in the billing determinants and the customer usage. So the benefit to the customers is implicitly included, and if there would be any discussions, it would be around, have you updated your customer usage to reflect the actual experience of the customer?
So what docket would be the appropriate docket if there was going to be a change in the methodology? Is this the appropriate docket to discuss a change in methodology?
I don't believe that it is. I mean, I believe that if we are going to change our procedures, we would need to change it in both the rate case and the EE rider in order to make sure that we stay consistent and there is no double counting.
Okay, so probably in the next year, what I hear you saying is that if there was a change in methodology, it should be brought up in the rate case.
Right. And I mean, I believe that the company's position is that there really isn't a need to change the process. What we have is working. And if we end up changing the process, we will then start adding a layer of complexity and estimation into both proceedings. Because if we change this in the rate case is based on actual customer KWH. And so if we want to say that the net lost revenues would be completely earned the first day of a measure, which is a fundamental difference in the definition of a net lost revenue. But if we were to say that, you would then have to do some kind of annualization of savings in the rate case. And I don't think that that's appropriate, but that would be the docket in which that discussion would need to take place.
Okay, thank you. And then one last question. In your rebuttal testimony, you do not mention witness Williamson's request in his testimony, and specifically it was his first recommendation that future EM and V reports on water saving measures include a more robust surveying of large occupancy homes in the data set in order to assess the reasonableness of the data. Do you agree with Mr. Williamson's recommendation?
I am not a program manager expert, so I would need to defer.
I can take that one on. Absolutely. Reading Mr. Williamson's testimony on a more robust survey for that program is something that we will undertake in the next EM&V evaluation and put some more substance around the questions that we're asking those customers to make sure we're diving deeper into that. The methodology that was applied to the EM&V was standard, but in reviewing, and listening to public staff's comments, we'll work on adding additional.
Okay, so that's a yes.
That's a yes.
Thank you. Okay, checking again, no other questions. Questions on commission questions?
No questions.
No questions. Okay, thank you very much for your testimony today. You are excused.
Thank you.
Presiding Commissioner Duffley, will now be the appropriate time to move the application into evidence.
Yes.
We'd move that the application be moved into the record.
So approved of, and grant that motion.
We'd like to also move that the exhibits, specifically Miller Exhibits 1 through 7, revised Miller Exhibits 1 through 4, Miller Rebuttal Exhibits 1 and 2, Fields Exhibits 1 through 14, Fields Exhibits A through J, and revised Fields Exhibit C also be moved into the record, please.
Okay, without objection, that motion is approved or granted.
Thank you.
The public staff now calls David Williamson, Hemant Mehta, and Michelle Boswell to the stand.
Do you all want to be sworn? Sure. Or affirmed? Okay, so if you could place your left hand on the Bible, raise your right. Do you solemnly swear that the testimony you're about to give this afternoon will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yeah, I do.
Mr. Williamson, would you please state your name, business address, and current position for the record?
Sure. My name is David Williamson. Business address is 430 North Salisbury Street, Raleigh, and I'm an engineer with the Public Staff's Energy Division.
On May 20th, 2024, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 14 pages and 1 appendix?
That's correct.
Do you have any changes or corrections to make to your pre-filed direct testimony?
I do not.
And if you were asked the same questions today, would your answers be the same?
They would be.
Mr. Mehta, would you please state your name, business address, and current position for the record?
Sure. My name is Hemant Mehta. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm a public utility regulatory analyst with the accounting division of the public staff.
On May 20th, 2024, did you prepare and cause to be pre-filed direct joint testimony in this docket consisting of 13 pages and 2 appendices?
Yes, I did.
Do you have any changes or corrections to make to your pre-filed direct joint testimony?
No changes.
If you were asked the same questions today, would your answers be the same?
Yes, they will be the same.
And Ms. Boswell, would you please state your name, business address, and current position for the record?
Michelle Boswell. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I am the director of the accounting division for the public staff.
On May 20th, 2024, did you prepare and cause to be pre-filed direct joint testimony in this docket consisting of 13 pages and 2 appendices?
Yes.
Do you have any changes or corrections to make to your pre-filed direct testimony?
I do not.
If you were asked the same questions today, would your answers be the same?
Yes.
Presiding Commissioner Duffley, at this time, I move that the pre-filed direct testimony and appendix of public staff witness David Williamson and the pre-filed direct joint testimony and appendices of public staff witnesses Hemant Mehta and Michelle Boswell be marked as identified and entered into the record as if given orally from the stand.
I approve that motion.
Thank you. The panel is available for cross-examination.
Proceed.
Good to see you all. Usually see your video, so it's nice to see you in person today. Just have brief questions on Ms. Boswell and Mr. Mehta's joint testimony to kind of set the foundation for that line of questioning. I'm going to read a statement in your testimony, and I'll give you a second to get there. But I'm looking at page 10, line 9, that public staff lays out the recommendation. And if you let me know when you get there, I can read it from there.
Yeah, read it.
Okay, and I'll read it and then just correct me if I misstate something, and then I'll have a question to follow off of that. Based on the results of the public staff's investigation, we recommend that the billing factors proposed by the company as set forth in revised Miller Exhibit 1 be approved by the commission, subject to resolution of the NLR potential double counting issues discussed below. Did I read that correctly?
Yes.
And so based off that statement, just trying to understand the public staff's position, really the only thing that's withholding your full stamp of approval is this net loss revenues issue that we're talking about today. Is that right?
That's correct.
Okay. And did you all review Ms. Miller's rebuttal testimony that was submitted after you all filed your testimony?
Yes, I did.
Okay. And in Ms. Miller's rebuttal testimony, did she identify any double count in net loss revenues?
So as part of our investigation, we have asked the company to provide reconciliation to see if there is any double counting because we had some concerns, and that has not been addressed.
Yeah, I understand that, and we disagree on some of that. Just back to my limited question, did Ms. Miller's rebuttal testimony identify any double count in net loss revenues?
Ms. Miller's testimony addressed the fact that they could not do a reconciliation, and I believe stated that the company found no double counting issues, but still did not provide the information that the public staff requested in verifying that information.
Okay, understand that. And last question, in the public staff's testimony, did you all identify any double count in net loss revenues?
No, we did not identify anything because we are not able to verify. So there is no way we could say it's double counting or not because we have requested the company for some data and the company has not provided that information.
And just one follow-up on that. Do you have any reason to doubt Ms. Miller's testimony about the information that was provided to public staff?
While the public staff doesn't doubt that that is her belief, we are tasked with not just trusting someone's belief, but actually verifying said data. And that's what we're trying to do, is verify that that statement is accurate.
Okay, and thank you very much. That's all I have.
Redirect.
No redirect. Thank you.
Commissioner questions? Okay, go
Ms.
ahead.
Boswell, what are you looking, what could they have provided you that they didn't provide you?
When we had discussions with the company before filing our testimony, we had asked them just to provide us a ballpark reconciliation. Show us where you haven't included these within the confines of the rate case and asking for them here within the confines of the DSMEE in whatever manner that they could do so. We kind of have the perfect storm here, and that to our recollection in the history of this, we've never had the rate case, a mechanism review, and a rider all in such close proximity to each other. And so in our review of all of those items, this question popped up was, can we verify that you have zeroed out essentially or held the ratepayers harmless from the inclusion of those net lost revenues that, whether explicitly or implicitly or however implicitly you want to describe it, in the rate case versus the mechanism. And we found in the course of all of our discussions, which were numerous with the company and trying to tie this down, that it really wasn't there. And to the company's testimony, evidently can't be done. And so from that, we're not really sure where to go.
Okay, so as I understand the company's rebuttal testimony, which came in subsequent, obviously, to your testimony, the company provided a written explanation of or a written response or to the question of whether double counting occurred. And so is it your position that sort of the explanation provided in the testimony aside, they haven't provided you the work papers showing you the actual determinants or whatever it is that you need to see?
Correct. And Mr. Williamson can help me explain part of this, but they calculate net lost revenues on a monthly basis. And they have the program participants and the kilowatt hours on a monthly basis. And so while appreciating that there are some things that you have to calculate using some kind, I don't want to say estimate, but some kind of
Proxy.
proxy, thank you, if you will, whether it's assuming everything occurs first of year or assuming everything's a mid-year convention or what have you. It is our belief that you have that information on a monthly basis. And whether or not it takes a month or two, or according to Mr. Fields, maybe a couple extra months, depending on the specificity of the program, you have that information in your systems and can show us on a monthly basis, since you have that information, how it flowed through versus utilizing this proxy, if you will, that they've chosen to utilize of the mid-year convention.
Okay, and just make sure I understand exactly what you're saying. Show us how it flowed through. So you want the company to show the public staff how a credit for a net loss revenue was passed on to the customers, either through the DSMEE rider or through the rate. Well, you answer my question. What is it, for the court reporter's sake, let me ask that question clearly. What is it that you want Duke to show the public staff?
It is verification that we haven't picked up those kilowatt hour savings or reductions, not savings in this case, sorry, within the confines of the rate case and still accounting for them within the confines of the DSMEE mechanism.
Okay, got it. Y'all's testimony, I just had the page and I've left, on page 12, you discuss, whether the commission approves the pending mechanism, and if it does, then this, and if it doesn't, then that. So the commission has since issued an order on the mechanism. And so is your concern, right, so help me understand the public staff's concern now in light of the order issued on the mechanism. Is the public staff's concern limited to this one particular case in time where we were between mechanisms and sort of in the middle of rate case year, or do you all have what you need going forward?
Yes and no. And I know that's clear as mud. So let me try to clarify. For residential customers, because of the mechanism that you all have approved, as long as there is a PBR rate case in effect, those net lost revenues will be deemed to be recovered within the decoupling mechanism. So therefore, we wouldn't have the net lost revenue recovery for residential within the confines of the DSMEE mechanism.
Got it. Okay.
So it resolves it as long as we have a PBR and an active decoupling mechanism. It doesn't resolve it for non-residential customers since we do not have a decoupling mechanism for non-residential customers. And it wouldn't resolve it for any year that we don't have a PBR in effect because we, by default, would revert back to the current methodology.
Okay. Thank you. All right. That's all I have. Thank you.
And you heard the questions that I asked the DEC witnesses. So if there was going to be some type of change of this, I'll call it a mechanism, what case is the appropriate case to hammer out that type of change in the mechanism?
Go ahead.
Well, I mean, having just recently concluded a mechanism review, I think we made a lot of strides in how to deal with net loss revenues going forward. I think the issue that we have today is how do we deal, because the new mechanism hasn't gone into effect yet.
Right.
So how do we deal with a rate case occurrence, which isn't every year, and so it's every couple years, it feels like this rate case reset has occurred. And so it's just trying to ensure that the reset has been applied appropriately. And so in this case, I think I kind of go back to Witness Miller's rebuttal exhibit number 1, where she's kind of spelled it out as far as how the company has applied this reset. And really the main issue is this test period, July 1, 2022 through June 30th, 2023.
Are you in the middle bucket?
Yes, ma'am.
Okay.
The middle bucket. Because the left bucket is basically saying that it's been zeroed out. There's no more net loss revenue recovery. And then the far right bucket for everything beyond July 1. After the true up period, it's as if it's the continuing to build the net loss revenue bucket for the rider proceeding, or soon to be through the decoupling. But we're trying to ensure that this time period of July 1, 2022 through June 30th, 2023 has been handled appropriately. And it appears that there's just been a just a percentage allocation applied to that time period, whereas there is enough data, should be enough data to discern which month net loss revenues has been accrued for each month during that period, and which month should be reset to zero or continued on at full value.
And so to follow up that, I'm just trying to understand public staff's request, which I know is have the company provide the information to public staff. But if we've all read their rebuttal, but what is it that you're requesting that the commission do? Because again, for that middle bucket, it's that kind of 50%. So if you were the company, how would you account and figure out that middle bucket?
So I think
any one of you can answer this.
So I think the main question is, what month does that reset period begin? And that's really the big question. Is what they've applied right here is a 12-month kind of a reduced value almost for the net loss revenues with this 50%. And so it's just trying to figure out, in my mind, it's either zero or it's the full value of the net loss revenue that it equates to. But what's been applied in this middle bucket is a kind of reduced percentage. And so it's just whether or not, I don't believe, to my knowledge, the mechanism addresses a kind of mixed value. To me, it just kind of reads as you're either reset to zero or you just continue on accruing the net loss revenues in the net loss revenue bucket.
Okay, so what I heard you say, testify to, is instead of having that 50%, you just go to one side or the other, have it be zero or have it be 100%.
Depending on when the reset month occurs. Okay. And so that's what we're trying to figure out, is what month is that reset month?
So, Commissioner, you wanted to ask a question, follow-up question? I'm not done, but I'll let you pop in. Okay. So could you also explain, obviously the 2020 mechanism order that was issued, the testimony of the company is that this has not been brought about. Can you explain why this is the first time that this issue is coming up?
Sure. And I think it's just a matter of the reading of that paragraph. The public staff believes that it's really clear that when you have a rate case, you would reset, it's the 36-month period ends and you move forward. The company reads it differently. And so it hasn't come up before because, like I said, when we go through an audit, in as much as I would like to say that we look at everything in every case, there's simply not enough time. And so when we're in any of the cases, we are looking at what is the biggest piece of the pie, so to speak, what is most likely to be incorrect or contain errors and have the most impact to ratepayers. And so in the DSMEE, we haven't had the perfect storm in our recollection of having a rate case, a mechanism review, and a rider all in such close proximity. And so when our staff began looking at all of it and making for sure that we had paired all of the pieces together, this issue came up of how do we tie this in? How do we verify this? And that is what we broached with the company on many occasions, is help us to tie this in. Help us to see that it may not come down to every kilowatt hour or every dollar, and that's okay because there are estimates involved within the DSMEE.
Correct.
And we all know this. But get us into the relative ballpark of the game that we should all be playing the same game of. Just show us that we're within the same ballpark and we move on. And to date, we don't have that to be able to say that we're ready to do that.
Okay, thank you. And tell me your view on this language. You know, at the end of the paragraph 60 of the order, it says they state that the public staff ignores this to the extent the rates set in the general rate case or comparable proceeding are set to explicitly or implicitly recover net loss revenues associated with those kilowatt hour sales reductions. Can you respond to that argument that the company's making?
Absolutely. We're not ignoring that sentence. And actually, that's what gave rise to our concern is that, okay, we've got the language as it sets forth here. So we still have to be able to show that it does those things. And right now we can't show that it does those things.
Okay, thank you. And Commissioner Hughes.
Yeah, I'd be a lot more comfortable if I had a spreadsheet with formulas in front of me. Doing that. But I'm just with, I think I understand where you're going. And just to follow up on some of my colleagues' questions. First off, the 50% number, from what I understand all along, that the MyHER program's lost revenues dominates the rider calculations in every single way. And through past riders and testimony and questions, it's my understanding that those never reset. So that part of net lost revenues, which dominates in an amount, especially on the residential side, it's 70% of the net lost revenues total. They're not going to get reset.
Correct.
Okay, so I was just confused. I was a little confused about the 50%. I know I should have asked that to the Duke panel instead of you, but is that your understanding too, that what you're looking for are these other programs, which in a total of what the rider is collecting is going to be relatively modest compared to the net lost revenues that are in the MyHER program?
Right. As the mechanism currently stands today, absolutely, you're correct. In the mechanism that you all have approved, we're hoping to see more of a change associated with it not being as reliant on MyHER. And so in the future, we think that if there's a non-PBR rate case and we're reverting back to this standard, that we would have a larger issue at that point in time.
And so I guess to add a little bit of clarity to that, I kind of go back to Fields Exhibit 2 with regards to this, and that's the net loss revenue accumulation
I do have that one in front of me.
spreadsheet. And I guess to put a little bit more emphasis about what we're talking about here and the dollar impact is there are so as you can see, there's tons of years involved in the net loss revenues because they're allowed per the mechanism to accumulate up to 36 months of net loss revenues to be recovered. But in every preceding rider, you have to request the next 12 months of that 36 months. And so that's why you see in some of these vintage years, some of them have 3, some of them have 4, but it's trailing ends. So I guess some of the concern that's here is there are additional requests from that vintage 2022 and vintage 2023 installs that are in here that trail out into this current vintage year 2025. And so there's a prospective component for residential and the non-residential that are being added to the rate being asked for in this proceeding that fall in that 2022 and 2023 time period of the rate case where the net loss revenues would be reset. And so the question is more of, in that time period, what is the appropriate amount of net loss revenues that should be allowed for inclusion in 2025 vintage year for residential and non-residential net loss revenues? And so it's kind of the whole point of the reset is when a rate case concludes, or however it's interpreted with the reset, whichever month that falls on, 36 months are going to continue, but that doesn't mean that you're entitled to the full 36 months. You might be cut short because the company has since been made whole through the general rate case. And so the lost revenues for those past measures have been handled. doesn't mean that the installs after the general rate case test year, they are still getting the full value and they're included in the rider as if the rate case had never occurred. But that's what we're trying to deal with, is to make sure that the 2025 ask in this case is for net loss revenues is handled as it should be. So I hope that answers.
Yeah, no, it does exactly. So if they had provided a column where as if the rate case did not occur, and they had provided that next to the column that's in the rider, so that you would see 2025 with no rate case, 2025 with the rate case having occurred, would that have given you comfort to see that there was a significant drop in that column? Does that make sense?
That does make sense. I'd have to leave that to the accounting folks to respond to, but it's my understanding that through the numerous discovery that we did send on trying to drill into this, that because all of this is Fields Exhibit 2, and this feeds into Miller's exhibits. I believe it's just Miller Exhibit 1, where it's just kind of giving a summary of all the different rate components, but it's applied already. There is no highlight of the reduction as a result of the rate case change. And so that's what we're trying to dig into, is what is the impacts of the rate case per the mechanism in order to show us and verify to us that this has occurred.
Got it. Okay, thanks.
Any other commissioner questions?
Okay, questions on commission questions?
Limited, if that's okay, Presiding Commissioner.
Proceed.
Okay.
May I ask one
Yes.
question? Okay, guys, before we lose the opportunity, just, I'm not clear on the public staff's position, and I may never get there because I'm limited in my capabilities. But, okay, so is it the fact that Duke uses this estimate at 50% that's troubling to you, and you want to see actuals?
It's not
For that 2022, 2023 period? And so first answer that question.
I think what the public staff's trying to get to is what month per the mechanism should be the cutoff month between the reset of net loss revenues and the continuation, the full value of the net loss revenues.
Say that again, what month?
Which month should be the cutoff period for the reset of the net loss revenues?
Should be the cutoff period for the reset. Does that mean at what period of time should the reset begin?
At what period of time has the net loss revenues been recovered implicitly through the rate case that's been recently concluded?
Through the base rates. So,
Yes,
so really the question is, make sure I'm understanding. You've got the base rates that have been set in the rate case. And then what is the first month that NLR should be recovered in the rider again?
Correct.
Should begin again to be reflected in the rider. Is that the question?
That's correct.
And you all were never able to come to an agreement on that exact point in time with Duke?
No, ma'am.
Okay. And then help me understand your understanding of the 50%. How does the 50% work here?
So the company has used a mid-year convention and assumed that half has occurred before July 1st and the other half has occurred after July 1st. And so they get to an approximate 50%. I actually think it's like 50.46, subject to check. But that they've assumed that half of it is occurring at the beginning of the test year or at the beginning of the calendar year, and half is occurring at the end of the calendar year, regardless of when it actually occurred.
Okay, and so is that not a different way of kind of getting at the same issue? Y'all want a date, and they've said, we're just gonna assume we're gonna assume a 50% of the NLRs for this period of time, this post-July 1 period of time.
And it may very well be, we were just looking for that verification that that methodology actually came to that actually held, because what they have indicated is they use this methodology regardless of when that cutoff, regardless of when the update period ends in a rate case. And so for us, it's verifying that this is actually representative and actually does what it needs to do.
Okay, I think maybe I get it, but so Ms. Miller's testimony refers to an extended test year, and you're using the term update. Or do you all mean the same?
Yes.
Do you all mean the same thing there? Just want to make sure.
I believe so, yes.
Okay, all right, well, Duke's counsel can clear that up if they're on questions, on commissioners' questions, but just so want to make sure we're all on the same page here. Okay.
And I have a follow-up, because that's what I understood, is you're trying to figure out this middle bucket.
Right.
I mean, and you want the verification. They're saying that they cannot give the verification, but so that's where I was trying to get with my earlier question is, how do you get to a potential methodology like the 50% that everyone's comfortable with? Because if they could provide you the verification, it would depend on the year. Some years it's going to be one side, and other years it might fall on the opposite side. So could it be just a reduction of, instead of using 50%, using some other formula? That's where I was getting to, is how the two of you can come to a resolution, and then about the methodology, the formula in that middle space, and what is the appropriate case to do that in? Is it in a rider? Is it in the rate case, or is it in the methodology case?
I would say that you would have to start the process within the confines of a rate case. I don't know that there's a lot. I think you could then, once you have that in place, then you could put that within the confines of the mechanism. I think the mechanism as it stands now just says you'll reset them, and it's silent to the methodology. So I don't think we would be going against the mechanism to work that out within the confines of that rate case, or hopefully before we get to a rate case, so that when the rate case comes, everyone is in agreement on something.
Yeah.
Theoretically.
And so I guess just to add to that, it's my understanding that I don't know if a methodology for an allocation is necessarily needed whenever on a monthly basis we're determining the net loss revenues that are going to be claimed for that particular month in a given vintage year. And so you're either claiming it or you're not claiming it. And so that vintage year would be a reflection of what you can claim. And it's just highlighting what is claimable.
Okay, thank you. Any other questions?
Yes.
Chair Mitchell?
So, Mr. Williamson, then, so is it as simple for you and for you all that they are tracking the data month to month for DSMEE rider purposes, and you want them to pick a point in time, and so so the point in time, before that point in time, any of those NLRs would be reflected in the base rates that have been set in the rate case. And after that period of time, those NLRs are collected through the DSMEE rider.
That's correct.
And so you all believe that they've got that data, they have that data on a monthly basis, and just didn't provide it to you?
I do believe they have it on a month-to-month basis. I don't know the discovery responses that accounting reviewed on this matter.
And then keep in mind, this is only if we don't have a PBR, except for non-residential, which it would occur regardless.
But it's the case in this proceeding.
Case, yes.
And I understand the implications for the future, but we have to resolve it in this case.
Absolutely.
Okay. Okay, thank you for letting me ask my question.
Sure. Okay, commission questions on commission questions.
Yes, limited questions. All right. Appreciate your testimony. Want to just give me a couple seconds to kind of walk back through so I can orient you all as to where my questions are coming from the commission. All right. So this for panel's probably best for Ms. Boswell and Mr. Mehta. I think Chair Mitchell asked a question about whether you received work papers. I think she specifically cited billing determinants. And I just want to make sure that the answer is clear so that we have it on the record. Did you all receive work papers containing billing determinants from the rate case?
Yes, we did.
And did you all also receive customer growth pro formas that were updated for usage by residential and non-residential customers?
Are you talking about within the rate case?
No,
Within the
have you
rider.
ever received that from the company in the context of net loss revenue discussion?
No. No, and for the context of net loss revenues, it's essentially determined on customer participation, savings assumptions from E and B, and then I've always called it the retail rate, but Ms. Miller called it the lost revenue rate earlier when she was on the stand. But it's number of customers, the amount of savings, customers or measures, number of savings per customer per measure multiplied by that dollar value to come up with the monthly lost revenue for that month.
And so you've not received customer growth performance from the company in the context of this discussion of net loss revenues?
In this rider, no.
No.
Okay. Have you received backup support evidencing any kilowatt hours removed from the test period in the EE rider?
Removing? Can you clarify?
Have you received any information from the company which the company believes demonstrates removing kilowatt hours from the test period in an EE rider?
We received from the company what their illustration of the 50% was as far as on a tiered based, stair-stepped, for lack of a better term, basis.
Okay. Thank you,
I
Ms.
don't know if
Boswell.
that was what you were looking for.
I didn't mean to cut you off, but yes, that's helpful. Thank you. Just quickly, a couple of other questions. I believe you received questions from Presiding Commissioner Duffley about the methodology we're all discussing. And so I want to follow up on that. Isn't it true that the mechanism sets parameters or guideposts for that methodology that the company has to operate within to calculate this number?
Yes.
Okay. And did public staff raise this issue in the recently completed mechanism review where we were reviewing the mechanisms and proposing changes and revisions?
We did not, as we are reading it differently than the company is. So upon our reading of it, when we were doing the mechanism review, we thought it covered what it needed to cover.
Okay.
And then the mechanism review was a going forward approach at the time of, I don't know if you remember, but the mechanism review was a very long, lengthy process. And so those conversations were being had over a number of months, whereas this has been filed since, I think, late February of this year. And so the presumption while we were going through the mechanism review was that the language was fine as it was. It wasn't until we got into this proceeding that we were coming to a disagreement on the language and how to apply it.
Okay. So just so I'm clear, you characterize it as a long and lengthy process. Nowhere in that
The
long.
mechanism review was a long, lengthy process that took many months, many hours of everyone's time in order to come to the agreement that we came to that was approved by the commission.
Yeah, I agree with you wholeheartedly. Just limited question. Nowhere in those long, lengthy discussions did public staff raise this concern.
I have to say one thing, like, as we have told, as you have mentioned earlier, like when we were in the last 12 months, when we have looked at the rate case, the mechanism review, and looking at the rider, when we putting all these puzzles together, that's when we realized, is there something happening? Is there a double counting happening? So that's when we had some concerns, and that's when we raised the issue. It is not during the mechanism process we have raised the issue.
Right. And to answer your question, no, we did not bring it up. And in large part because as all of the parties were working their way through the mechanism, it is trying to peel apart what are the biggest issues at play. And like I said before, it was our understanding that this language covered what it needed to cover, just like it's the company's understanding that this language covers what it needs to cover. We just have different interpretations of what that coverage is.
Thank you, Ms. Boswell. Thank you, Mr. Mota. Thank you, Mr. Williamson. That's all the questions from the company.
Just one. Was this issue on your radar when we filed our initial comments for the mechanism review?
It was not.
Okay, that's all the questions I have.
Okay. Thank you all for your testimony this afternoon. You may be excused. Ms. Keyworth, I'll accept motions.
Thank you, Presiding Commissioner Duffley. The public staff moves that the pre-filed direct testimony of public staff witness David Williamson and the pre-filed direct joint testimony of public staff witnesses Hemant Mehta and Michelle Boswell be entered into the record.
And the testimony has been entered into the record, and that's with the no exhibits, right?
No exhibits.
Okay, thank you. Okay, any further matters that we need to address? Okay, so proposed orders and briefs will be due 30 days from the notice of publication of the transcript, and I thank you all, and we're adjourned.